Vanakkam. We are all assembled here to conduct this concluding session. Today's Law and Justice Conference will resume now. இன்றைய மாலை நேர நிகழ்ச்சிக்கு I am requesting Honorable Justice P. Kalayarasan, Chairman, Tamil Nadu Official Language Commission, to preside over this conference.
Former Judge, Supreme Court of India, the chief guest of today's function, 28th Sattakadir Global Conference on Law and Justice, Dr. G. Viswanathan, founder and chancellor VIT University, special guest. The speaker, Dr. G. Narayana Raju, Secretary, Ministry of Law and Justice, Government of India. Mr. P. Wilson, Member of Parliament, former Additional Solicitor General of India. Dr. A. Tyagarajan, Senior Advocate. Mr. S. Sirikanta Raja, Attorney, London, UK. Dr. Raghunath Reddy, Professor, Bharat Institute of Law, Bharat University. Sister Prem Rajkumari, Advocate, New Delhi. And Dr. Meenakshi Sundaram, Advocate and Member of Editorial Board, Sattakadir. Dear friend, Dr. V.R. Sampath, brothers and sisters. Good evening, all of you.
Good evening,
I deem it a pride and privilege to preside over today's concluding session of this conference. At the outset, I would like to appreciate Dr. V.R. Sampath for his consistent efforts in conducting conferences on various topics, especially conference on law and justice, and I also congratulate him for bringing out a Tamil law journal, Sattakadir, as a service to the legal fraternity without any profit and pecuniary benefit being reaped out of it. The aim of this conference is that to address a number of issues we face on law and justice, including administration of justice. When we think of effective implementation of principles of administration of justice, the language of the courts plays a vital role. In this connection, I would like to expound and explain the functions of State Official Language Legislative Commission in Tamil as the chairman of the commission. It has to be placed on record that the contributions of the State Official Language Commission were instrumental and encouragement to Government of Tamil Nadu to bring Tamil as language of subordinate courts of Tamil Nadu. இந்திய அரசமைப்பில் வழங்கப்பட்டுள்ள அதிகாரங்களை பயன்படுத்தி இந்தியாவில் உள்ள மாநிலங்கள் தங்கள் மாநில மொழிகளை அம்மாநிலத்தின் ஆட்சி மொழிகளாக அறிவித்துக் கொண்டன. அந்த வரிசையில் தமிழகத்தின் ஆட்சி மொழி தமிழ் என்று தமிழ்நாடு ஆட்சி மொழி சட்டம் இயற்றப்பட்டது. 6 பிரிவுகளை கொண்ட இச்சட்டத்தில் 4வது பிரிவில் மாநில அரசு அவ்வப்போது அறிவிக்கை வாயிலாக தெரிவிக்கும் துறைகளில் மட்டும் தமிழ் ஆட்சி மொழியாக செயல்படுத்தப்படும் என்று குறிப்பிடப்பட்டது. அதன்படி தமிழ்நாடு அரசு துறைகளை பட்டியலிட்டு அறிவித்த போதும் நீதித்துறையில் தமிழை ஆட்சி மொழியாக அறிவிப்பதற்கு போதிய அடிப்படை சட்டங்களும் விதிகளும் தமிழில் மொழிபெயர்த்து வழங்கப்படாத காரணத்தாலும், சட்ட அகராதிகள் வெளியிடப்படாத காரணத்தாலும் சார்நிலை நீதிமன்றங்கள் ஆங்கில மொழியினையே நீதிமன்ற மொழியாக கொண்டு செயல்பட்டு வந்தன. இந்நிலையில்தான் மாநில சட்ட ஆட்சி மொழி ஆணையம் சார்நிலை நீதிமன்றங்களில் தமிழை நீதிமன்ற மொழியாக மேற்கொள்வதற்கு ஏதுவாக இந்திய தண்டனை சட்ட தொகுப்பு, அதாவது ஐபிசி, இந்திய சான்று சட்டம், இந்தியன் எவிடன்ஸ் ஆக்ட், குற்றவியல் நடைமுறை சட்ட தொகுப்பு, கிரிமினல் ப்ரொசீஜர் கோட், உரிமையியல் நடைமுறை சட்ட தொகுப்பு, சிவில் ப்ரொசீஜர் கோட் ஆகியவற்றை தமிழில் மொழிபெயர்த்து வழங்கியது. இதன் பின்னரே தமிழக அரசு தமிழ்நாடு ஆட்சி மொழி சட்டத்தில் சார்நிலை நீதிமன்றங்களில் தமிழை ஆட்சி மொழியாக செயல்படுத்துவதற்கு வகை செய்யும் பிரிவு 4A, பிரிவு 4A என்னும் 2 சட்ட திருத்தங்களை கொண்டு வந்தது. எனவே தமிழ்நாட்டு சார்நிலை நீதிமன்றங்களில் தமிழை ஆட்சி மொழியாக சட்டம் அறிவித்ததில் மாநில சட்ட ஆட்சி மொழி ஆணையத்தின் பங்கு குறிப்பிடத்தக்கது என்பதை தெரிவித்துக் கொள்கிறேன். மாநில சட்ட ஆட்சி மொழி ஆணையத்தின் பணிகளை விரிவாக காண்பதற்கு முன்னர் இந்த ஆட்சி மொழி ஆணையம் குறித்த சில செய்திகளை பகிர்ந்து கொள்ள விரும்புகிறேன். தமிழ்நாடு அரசு ஆட்சி மொழி சட்டத்தை இயற்றியவுடன் 1957 சட்டங்களை தமிழாக்கம் செய்ய வேண்டும் என்றும் நடவடிக்கைகளை முதற்கட்டமாக அதிகார குழு என்னும் பெயரில் ஒரு குழுவை அமைத்தது.
Please switch off mic. Please switch off.
இதுவே முதற் குழு ஆகும். சென்னை பல்கலைக்கழக பேராசிரியரான ராபி சேதுப்பிள்ளை தலைமையிலான இக்குழுவில் 3 உறுப்பினர்கள் இருந்தனர். இதன் பின்னர் சென்னை உயர்நீதிமன்ற தலைமை நீதிபதி அனந்த நாராயணன் அவர்கள் தலைமையில் 2வது குழு அமைக்கப்பட்டது. இக்குழுவில் 9 பேர் உறுப்பினர்களாக இருந்தனர். பின்னர் 1976 சென்னை உயர்நீதிமன்ற நீதிபதி சு மகாராசன் தலைமையில் 3வது குழு அமைக்கப்பட்டது. இக்குழுவில் 10 பேர் உறுப்பினர்களாக இருந்தனர். இதற்கு பின்னர் 1989 ஆட்சி மொழி ஆணையம் திருத்தி அமைக்கப்பட்டு தமிழ் சட்டப்பேரவைத்துறை செயலாளர் திரு சண்முக சுப்பிரமணியம் தலைமையில் 4வது குழு அமைக்கப்பட்டது. இக்குழுவில் 4 உறுப்பினர்கள் பதவி வகித்தனர். நீண்ட இடைவெளிக்கு பிறகு, அதாவது 1989க்கு பிறகு 2018 இன்றைய தமிழ்நாடு அரசு மாநில சட்ட ஆட்சி மொழி ஆணையத்தை புதுப்பித்து அரசாணை வெளியிட்டது. ஆணைய தலைவர் மற்றும் 6 உறுப்பினர்கள் கொண்டு இவ்வாணையம் இப்போது செயல்பட்டு வருகிறது. மாநில சட்ட ஆட்சி மொழி ஆணையத்தின் பணிகளை நான் 3 வகையில் பிரித்து விளக்க விரும்புகிறேன். 1, இந்திய அரசமைப்பு வெளியீடுகள். 2, சட்ட 3, மைய அரசு சட்டங்களின் தமிழாக்க வெளியீடுகள். இந்திய அரசமைப்பு வெளியீடு என்று எடுத்துக்கொண்டால், இந்திய குடிமக்கள் ஒவ்வொருவரும் அறிந்து கொள்ள வேண்டிய சட்ட முன்னோடி ஆவணங்களில் ஒன்றாக திகழ்வது இந்திய அரசமைப்பு, கான்ஸ்டிடியூஷன் ஆஃப் இந்தியா ஆகும். தமிழ்நாட்டு மக்கள் தங்கள் தாய்மொழியில் படித்து அறிந்து கொள்வதற்கு உதவும் வகையில் தமிழ் மொழியில் மொழிபெயர்க்கப்பட்டு வெளியிடப்பட்டு வருகிறது. மாநில சட்ட ஆட்சி மொழி ஆணையம் 1988 தமிழில் மொழியாக்கம் செய்து வெளியிடப்பட்டது. 1992 2009 அரசமைப்பு ஆங்கிலமும் தமிழும் சேர்ந்து இருமொழி பதிப்பாக வெளியிடப்பட்டுள்ளது. தற்போது இந்திய அரசமைப்பின் 103வது திருத்தம் வரையிலான திருத்தங்களுடன் சேர்ந்து திருந்திய பதிப்பாக ரிவைஸ்டு எடிஷன் வெளியிடுவதற்கான பணிகள் வேகமாக நடைபெற்று வருகின்றன. இன்னும் சில மாதங்களில் அரசமைப்பின் 4ஆம் பதிவு திருத்தங்களுடன் வெளியிடப்படும் என்பதை தெரிவித்துக் கொள்கிறேன். 2, சட்ட கலைச்சொல் அகராதிகள். சட்டங்களை மொழிபெயர்ப்பதற்கு அடிப்படை ஆதாரங்களாக இருப்பவை சட்ட கலைச்சொற்களாகும். எனவே இதனை கருத்தில் கொண்டு சட்ட ஆட்சி மொழி ஆணையம் சட்டங்களை மொழிபெயர்க்கும் பணியில் ஈடுபடுவதற்கு முன்னர் சட்ட கலைச்சொல் அகராதியை 1968 வெளியிட்டது. தமிழில் வெளியிடப்பட்ட சட்ட கலைச்சொல் அகராதி தான் இந்திய மொழிகளில் வெளியிடப்பட்ட முதல் சட்டக்கலை சொல் அகராதியாகும். இந்தி மொழியில் 1970ஆம் ஆண்டில் தான் சட்டக்கலை சொல் அகராதி வெளியிடப்பட்டது. எனவே சட்ட கலைச்சொல் அகராதி வெளியீட்டில் தமிழகம் இந்திய மாநிலங்களுக்கு முன்னோடியாக திகழ்கிறது என்பது நமக்கு பெருமிதமாகும். இதனைத் தொடர்ந்து மேலும் 2 அகராதி தொகுதிகள் வெளியிடப்பட்டன. தற்போது ஆணையத்தில் இதுவரை வெளியிடப்பட்ட சட்டங்களிலிருந்தும் வளர்ந்து வரும் அறிவியல் துறைசார் சட்டங்களிலிருந்தும் சட்ட கலைச்சொற்கள் தொகுக்கப்பட்டு ஒரு முழுமையான அகராதியை தொகுக்கும் பணி நடைபெற்று வருகிறது. இத்தொகுப்பு முழுமையடைந்ததும் ஏறக்குறைய 17,000க்கும் குறையாத சட்ட கலைச்சொற்களை கொண்ட அகராதி ஒன்று வெளியிடப்படும் என்று நாங்கள் உறுதியாக நம்புகிறோம். 3, மைய அரசு சட்டங்களின் மொழிபெயர்ப்பு வெளியீடுகள். மாநில சட்ட ஆட்சி மொழி ஆணையம் இந்திய நாடாளுமன்றம் இயற்றியளிக்கும் சட்டங்களை தமிழாக்கம் செய்வதை தனது தலையாய பணியாக கொண்டுள்ளது. தமிழ்நாடு அரசின் சட்டங்களை தமிழக சட்டத்துறையின் கீழ் செயல்பட்டு வரும் தமிழ் பிரிவு மொழிபெயர்த்து வருகிறது என்பதையும் நான் இங்கே சுட்டிக்காட்ட விரும்புகிறேன். எனவே ஆணையம் இதுவரை 200க்கும் மேற்பட்ட மைய அரசு சட்டங்களை தமிழாக்கம் செய்து இந்திய குடியரசுத் தலைவரின் இசைவனை பெற்று நூல்களாக வெளியிட்டுள்ளது. தற்போது இருக்கும் இந்த ஆணையம் பதவியேற்றதிலிருந்து 30க்கும் மேற்பட்ட மைய அரசு சட்டங்களை மொழிபெயர்த்துள்ளது. அவை மைய அரசின் சட்டத்துறையின் ஒப்புதலை பெறுதல், குடியரசுத் தலைவரின் இசைவை பெறுதல் என்ற அலுவலக நடைமுறையில் இருந்து வருகின்றன. பொதுமக்களின் அன்றாட வாழ்க்கைக்கு பயன்படும் சட்டங்களை மொழிபெயர்த்து வெளியிடுவதற்கு ஆணையம் முக்கியத்துவம் கொடுத்து வருகிறது. மைய அரசின் சட்டத்துறையும் ஒவ்வொரு ஆண்டும் மொழிபெயர்க்கப்பட வேண்டிய சட்டத்தின் முன்னுரிமை பட்டியலை பிரியாரிட்டி லிஸ்ட் அனுப்பி வைக்கிறது. மேற்படி மைய அரசு சட்டங்களை மொழிபெயர்த்து நூல்களாக வெளியிடும் பணியில் ஆணையம் ஈடுபட்டு வருகிறது. தமிழ்நாட்டு நீதிமன்றங்களில் தமிழ் வழக்காடு மொழியாகவும் தீர்ப்பு மொழியாகவும் வர வேண்டும் என்பதுதான் ஆணையத்தின் முக்கிய நோக்கமாகும். அதனை எட்டும் வகையில் ஆணையம் உறுதியாக செயல்பட்டு வருகிறது. எனினும் வழக்கறிஞர்கள், சார்நிலை நீதிமன்ற நடுவர்கள், சட்ட ஆர்வலர்கள் அனைவரும் இந்த நோக்கத்தை நிறைவேற்றும் பணியில் துணை நிற்க வேண்டும் என்பதையும் இந்த நேரத்தில் எனது அன்பான வேண்டுகோளாக இங்கு உங்கள் முன் வைக்க விரும்புகிறேன். மக்களாட்சியில் நீதிமன்றங்கள் அந்நாட்டின் மக்கள் மொழியில் நடைபெறுதல் வேண்டும் என்பது இயற்கை விதி என்பதை நாம் அனைவரும் நன்கறிவோம். எனவே நீதிமுறை நிர்வாகத்தில் பணியாற்றும் அனைவரும் ஒன்றிணைந்து செயல்பட்டால் தமிழ்நாட்டில் சார்நிலை நீதிமன்றங்களில் மட்டுமல்லாமல் சென்னை உயர்நீதிமன்றத்திலும் தமிழ் மொழி வழக்காடு மொழியாக வருகின்ற நாள் விரைவில் அமையும் என்ற நம்பிக்கையில் எனது உரையை நிறைவு செய்கின்றேன். இந்த நல்ல வாய்ப்பை நல்கிய டாக்டர் பி.ஆர். சம்பத் அவர்களுக்கு நன்றியை தெரிவித்துக் கொள்கிறேன். நன்றி, வணக்கம்.
Honorable Judge, you've given a wonderful speech about the Tamil Nadu Official Language Commission. Tamil Nadu ஆட்சி மொழி ஆணையம் தமிழ்நாட்டில் நீண்ட நாட்களாக அதாவது நிலுவையில் இருந்த பல்வேறு சட்டங்களை இப்பொழுது அதிவேகமாக மொழிபெயர்த்து வருகிறார்கள். அதனை முழுவதும் நம்முடைய தலைவர் அவர்கள் விளக்கமாக எடுத்து சொன்னார்கள். இதன் மூலமாக விரைவில் தமிழ்நாட்டில் பல மத்திய சட்டங்கள் தமிழில் தெரிந்து கொள்வதற்கான வாய்ப்புகள் நமக்கு கிடைக்கும். அதனை மிக செவ்வனே செய்து வருகிறது ஆணையம். ஆகவே ஐ எம் வெரி ஹாப்பி டு நோட் தட் our Tamil Nadu Official Language Commission doing wonderful job for the past 1 year, translating many central act into Tamil. It will be useful for the Tamil Nadu people to use for day-to-day activities. I'm requesting the Honorable Justice Mr. Gopal Gowda is arrived. Sir, Honorable Justice Gopal Gowda. Yes, he will be expected any moment. Honorable Justice Gopal Gowda. Honorable Justice Gopal Gowda. Yes, he will be expected any moment. And in the meantime, I am inviting Dr. G. Narayana Raju, Secretary, Ministry of Law and Justice, Government of India, New Delhi, to present his speech on judicial legislation and separation of powers. Sir, Dr. Narayana Raju is a professor in law and also working in long time in Ministry of Law and Justice. He served in different capacity. He visited Chennai many times. He participated in our conference last year, economic conference. He will present a wonderful speech for us. I'm very much happy to invite him to present his speech. Sir, unmute your mic.
Thank you, sir.
Okay.
Thank you very much for giving me this opportunity. Dr. V.R. Sampath, editor, Sattakadir Tamil Law Journal, conducting 28th Sattakadir Global Conference on Law and Justice. And I also thankful to Honorable Mr. Justice Kalaisaran, Chairman, TN Official Language Commission, Mr. Justice Gopal Gowda, former Judge Supreme Court, G. Viswanathan, founder and Chancellor, VIT Chancellor, VIT University, respected Wilson, MP, Senior Advocate, Srikanth Tyagarajan, Senior Advocate Srikant Raja, Raghunath Reddy, other honorable speakers. The topic today for me is judicial legislation and separation of powers. Now, the theme is whether judiciary can make laws in view of the separation of powers of the Constitution or not. That means to understand whether judiciary can make law under the doctrine of separation of powers, it is necessary for us to understand whether our Indian Constitution adopted separation of powers in its strict sense. Then why there is a separation of powers among three organs? You know, the state has three components. One is legislature, executive, and judiciary. Legislative power is to make law, executive power is to implement the law, and judiciary power is to interpret the law. Why we need to allocate these separate powers to separate organs means for a moment you think if these powers are given only one person or given only one body, then that body or that person can exercise these powers arbitrarily. He himself is making a law, he himself is implementing the law, he himself is adjudicating the law. When that is the case, sometimes it is possible for him to abuse these powers. It is possible for exercise these powers arbitrarily. Thereby, citizens may be denied fundamental rights and their liberties. That's why the long back Aristotle and Plato, great philosophers, have recognized that these state powers have to be given to different three branches. This theory or this concept of separation of powers has been scientifically articulated by Montesquieu in his great work, The Spirit of Laws. He allocated that the powers of the state must be distributed to three different organs, that is legislature, executive, and judiciary, so that each organ will function within its jurisdiction. Now we have to see whether these functions are clearly incorporated in the Indian Constitution strictly or not. Strictly, why I am saying strictly or not, if you see the American Constitution, you will find that these separation of powers have been strictly implemented under the American Constitution. For example, the American Constitution contains only 7 articles. First 3 articles are very important basic structure of the American Constitution. Article 1 says the legislative power shall be vested with the Congress. The executive power, Article 2, the executive power shall be vested with the President of America. Article 3, the judiciary power shall be vested with the Supreme Court of America. That means there is a clear vestige of these powers, clear vestige of legislative powers in the Congress, executive powers in the President of America, and judicial powers with the Supreme Court of India. There was clear vestige of all these 3 powers in 3 organs, but there is no such clear vestige of powers under Indian Constitution. Only you can see Article 53 vest the executive power with the President of India. He may exercise his executive powers by either by himself or through his subordinate officer. No other vestige of legislative powers in the parliament, no other vestige of judicial power in the Supreme Court of India. That means we have not adopted the doctrine of separation of powers clearly in its strict sense, vigorously. That it doesn't mean that we have not adopted this doctrine of separation of powers in our constitution. In fact, this separation of powers has been held by the Supreme Court in Keshavananda Bharati as a basic structure of the constitution. That means you can understand that our Indian constitution also recognized the doctrine of separation of powers. For example, you can find Article 52 to 78 contains the executive powers. Article 79 to 123 contains the legislative powers. Article 124 to Article 147 contains the judicial powers. That means their implied recognition of these legislative powers with the parliament, implied recognition of judicial powers with the judiciary, and express powers, vestige of powers in the executive for executive functions. The same spirit you can find in Article 50, Article 121, and Article 122 of the Constitution. Article 50 says the state shall endeavor to separate judiciary from the executive. That means there must be separation of judiciary from the executive. Article 121 says no discussion in parliament about the conduct of judges in parliament. Article 122 says the validity of the parliamentary proceedings shall not be questioned in any court of law. By seeing these articles, you can understand that we also recognize the doctrine of separation of powers in our constitution. However, there are overlapping in the sense judiciary sometimes enters into executive enters sometimes into legislature enters into judiciary and executive. For example, I will give some examples where legislative entering into judiciary. Legislature has the power of impeachment of judges. Legislative has power of revalidating the laws interpreted by the Supreme Court. Legislature has the power to punish the persons who commits breach of privileges. That means almost all these powers appears to be judicial powers. These judicial powers are being exercised by the legislature. That is one way of legislature entering into judiciary. Second, legislature entering into executive. Legislature will review the work of the executive. A legislature will impeach the president of India, sometimes under certain circumstances mentioned in the constitution. Then executive enters into judiciary also. Say, for example, executive will make appointment of judges. Executive will pardoning powers are there with the executive. Executive can exercise quasi-judicial functions. All these functions appears to be judiciary, but executive are exercising under the Indian Constitution. Then executive also exercise legislative powers. That is, the President of India under Article 123 of the Constitution promulgate the ordinances. Promulgation of ordinance is nothing but legislative functions. These legislative function is being exercised by the executive. In the same way, judiciary will enter into executive, where under Article 142 of the Constitution, for doing complete justice, and where the judiciary will question the executive actions. Then judiciary also enter into legislative field. That is, judiciary will say that a particular legislation is unconstitutional. Judiciary will say that a particular constitutional amendment is against the basic structure of the constitution. That means by seeing these things, there is some overlapping powers between executive and judiciary, judiciary to executive, executive and to legislature. We have not clearly adapted in its strict sense the doctrine of separation of powers in our constitution. That means there is some gaps, there is some overlapping issues in our constitution. This is why, because we have adapted our concepts from various constitutions. Say, for example, amendment theory. Amendment, we got it from Germany. For example, in America, if you see, the amending procedure of the American Constitution is very rigid. But our Constitution amendment is neither rigid nor flexible. And in same way, our concept of federalism, though we have adopted strict, some federalism principles, but there are so many exceptions. That's why our constitution is known as quasi-judicial constitution. So in view of these overlapping powers, we cannot say that we have adopted the doctrine of separation of powers strictly. But however, the Supreme Court in Keswanand Bharati held that doctrine of separation of powers is the basic structure of the Constitution. Now here you may question when we have not adopted the separation of powers strictly, how can we say that this separation of powers is the basic structure? Here the thing is, the essential functions of one organ cannot be taken away by other organ. Essential functions of one organ cannot be delegated to other organ. For example, essential functions means legislative functions cannot be given to judiciary, judicial powers cannot be given executive, executive powers cannot be given to judiciary or legislature. These are the essential functions. Why I call it essential functions? The framers of the constitution are the people while delegating their sovereign powers to these organs through constitution, they trusted these institutions, that these institutions are best in exercise of legislative powers, in exercise of executive powers, in exercise of judicial powers. So this trust has to be protected. This is protected by the constitution. If one organ takes the powers of other organ, then it amounts to breach of constitutional trust. That's why the essential functions, legislative functions cannot be taken by judiciary, judicial function cannot be taken by the executive. In that way, the Supreme Court in case Vanand Bharati held that it is a basic structure of our constitution. When they said that it is a basic structure of the constitution, neither parliament by making a law nor amending the constitution cannot be taken away the basic structure of the constitution. Now, in view of this background of theory, we now measure what is the judicial activism, what is the judicial power, what is the judicial review power, what is the judicial activism and judicial adventurism. Now, the question is judicial legislation. In view of this concept of the separation of powers, whether judiciary can make law or not, clearly, directly, I immediately I will give one article. Article 142 of the Constitution vests unfettered independent jurisdiction to pass any order in public interest to do complete justice if exercise of such jurisdiction is not contrary to any express provision of law. That means if there is no specific law in this any respect, then the Supreme Court may, under Article 142, issue any order or decree for providing complete justice to its citizens. I think the 2 days back, that Supreme Court has issued certain guidelines for the purpose of maintenance under Article 142 of the Constitution. Now, we will examine clearly whether judicial activism is possible under Indian Constitution in the background of such separation of powers. Now, as far as judiciary is concerned, its role is interpret the law and examine whether they are in accordance with the provisions of the Constitution or not. The courts not only interpret the law, but also give finality to it. Because of this finality, the judiciary appears to be a powerful organ. Its duty is to see that the other two organs are not to exceed their limits. While examining so, the judiciary must also ensure that it should not exceed its own limits. They themselves have to decide as to what is the extent of their limits. This is known as judicial restraint. Therefore, when we talk about judicial activism, we must also remember the importance of judicial restraint. Before we get into it, we must understand the distinction among judicial power, judicial review, and judicial activism. Judiciary, including subordinate judiciary, has been given a number of powers for discharging their adjudicatory functions effectively under various statutes, be it under substantive laws or procedural laws. These are the judicial powers. Judicial review power, on the other hand, was expressly given to the constitutional courts, that is, the High Courts and the Supreme Court, under Article 13, 2, 32, and 226 of the Constitution to examine the legislative and executive actions in conformity with the Constitution. Sometimes, judiciary, under the garb of judicial review, starts rewriting the law and constitutional provisions, which is known as judicial activism. Best examples are due process, basic structure theory, while the other immediate examples are when the Supreme Court gave number of directions to the government in the Vishaka state of Rajasthan, or in D.K. Basu versus state of West Bengal, or Lakshmikant Pandey versus Union of India. Therefore, it appears where judicial review ends, then the judicial activism starts. See, for example, I will say the due process clause and basic structure theory. Due process, originally we have not adopted due process under our Article 21 of the Constitution. Actually, the founders of our Constitution framers wanted to use the due process clause like American Constitution. In America, Fifth Amendment provides no person shall be deprived of his life, liberty, and property except due process. We wanted to adopt that same clause in Article 21 of the Constitution. But because of our advisor, constitutional advisor, B.N. Raoji, and when he held a discussions with Frankfurter, they clearly came to an understanding not to use this due process under our Constitution. That's why we used no person shall be deprived of his life, liberty, except according to procedure established by law. We have removed due process. But in Maneka Gandhi, while interpreting this clause, the Supreme Court has given wider meaning to this according to procedure established by law. According to Supreme Court, the procedure established by law must be just, fair, and reasonable. That is, the Article 21 has been widely interpreted, thereafter giving it scope for so many judicial activism principles. In the same way, if you see the basic structure theory, originally nowhere you will find this basic structure in the Constitution. But the Supreme Court in Kesavananda Bharati included additional restrictions on the amending powers of the Parliament, that whenever Parliament tries to amend the Constitution, it can amend any provision of the Constitution, but it cannot destroy the basic structure of the Constitution. So under judicial activism, these are the principles laid down by the Supreme Court. Judicial activism means strictly where the process of decision making is influenced by personal views of judges. Former Chief Justice J.S. Verma had said that judicial activism is a positive thing for active implementation of rule of law. Justice Rehnquist of the United States of America, on the other hand, said that judicial activism means judicial legislation. Black's Law Dictionary, on the other hand, defines judicial activism as a philosophy of judicial decision-making whereby judges allow their personal views about public policy to guide their decisions. For this purpose, it would be essential to understand judges. Judges may broadly be seen as conservative or liberal based on their social, political, and economic leanings. For instance, a conservative judge would subscribe only to the text of the law and apply it strictly. The view of the conservative judges is that they should be neutral adjudicators without making any legislation and rewriting the laws. This is because judiciary has no judicially manageable standards for such lawmaking. For example, if an economic policy has been introduced, it is not for the judiciary to see whether such a policy is required or not, as it has no judicially manageable standards to examine. Apart from that, they are of the view that what is good for the people is to be decided by the legislature and not by the judiciary. In contrast, the view of the liberal judges is to provide justice, equality, and liberty to the people as laid down in the preamble. To attain this goal, the judiciary has sometimes relaxed the rigor of law or sometimes issued necessary directions to the administration. However, in order to grasp the scope of constitutional power of judicial review and the consequent judicial activism, it is essential to see the genesis of these powers in the Indian legal system. In the American system, we have so many important landmark judges where the American Supreme Court has exercised their judicial activism principles. For example, Marbury versus Madison, Dred Scott versus Sandford, Plessy versus Ferguson, Brown versus Board of Education, Roe versus Wade. In all these cases, number of judicial activism principles have been laid down by the American Supreme Court. Coming to the judicial activism in India, judicial activism in India can be found under different categories like public interest litigation, under human rights, under environment, under compensatory jurisprudence, under social welfare, under constitutional amendments. Because of the wider interpretation given by the Supreme Court in Maneka Gandhi's case, we have relaxed the rigor of locus standi principle, that is public interest litigation. That means anybody whose rights have been violated, that person himself has to approach the Supreme Court as per a present existing law. But in view of this relaxation of the locus standi, why they have relaxed the locus standi means access to justice is a fundamental right. Access to justice is fundamental right. So, for example, poor persons, migrant workers, and minors, children, women, bonded labor, they cannot be expected to approach the Supreme Court in Delhi. That's why a public spirited person on behalf of these vulnerable group of persons may approach the Supreme Court by way of public interlitigation or by way of writing letters, by way of news items. The Supreme Court or High Courts has recognized this jurisdiction, which is known as epistolary jurisdiction. So under this relaxation of locus standi, the Supreme Court has delivered number of decisions which benefited so many persons. Say, for example, prisoners in Hussainra Khatun versus State of Bihar, in Municipal Council Ratlam, in SP Gupta versus Union of India, in Bandua Mukti Morcha, where bonded laborers were released, and also judicial activism cases in number of environmental protection cases, oleum gas leak case, Narmada Bachao Andolan versus Union of India, and in case of judicial activism, in case of fundamental rights, say for example, Maneka Gandhi's case, where the interpretation is given in wider way, and in Mohini Jain, for example, where the right to education was made as implied fundamental rights. In like that, this Article 21 has been widely interpreted by the Supreme Court. Now you will find almost 30-35 rights impliedly included in Article 21 of the Constitution. Recent one is, I think privacy was made as implied fundamental right in the under Article 21 of the Constitution. In the same way, we will find judicial activism in case of compensatory jurisdiction. Rodal Shah versus State of Bihar, and Neelabati Behra versus State of Orissa, State of AP versus Challa Ramkonda Reddy. In all these cases where life has been threatened to any prisoners, then court was ready to pay the compensation. That means the court is ready to direct the government of India or government of the state to compensation for the deprivation of their life and liberty. In the same way, you can find judicial activism in case of constitutional amendments. For example, in Golaknath, famous case Golaknath, where the Supreme Court held that Constitution, while amending the Constitution, the Parliament cannot take away the fundamental rights of the Constitution. To do away this Golaknath judgment, a 24th Amendment was brought to nullify the judgment of the Golaknath case. While deciding this 24th Amendment, the Supreme Court in Kerala, Kesavananda Bharati versus Union of India, Kesavananda Bharati versus State of Kerala, held that though 24th constitutional amendment is valid, though Parliament has power to amend any provision of the Constitution, but it cannot destroy the basic structure of the Constitution. That means new concept was imposed by the Supreme Court upon the amending powers of the Parliament. In the same way, you can find these judicial activism principles in Indira Gandhi versus Rajnarayan, in Minerva Mills versus Union of India. Recently, the Supreme Court has developed a new concept of constitutional morality. Under this constitutional morality, also they held that Section 377, 397 of the IPC were held unconstitutional, and invoking this constitutional morality also, they have decided Sabarimala case. Then coming to this actual judicial legislation issue, although lawmaking power was given to Parliament, but Supreme Court under Article 142 of the Constitution, read with Article 32, these provisions are responsible for judicial legislations. Because of Maneka Gandhi procedure established by law as fair, just and reasonable, it has led to rise in number of social action legislations with the evolution of fundamental rights and directive principles of state policy. With a view to see whether this judicial activism does not become judicial adventurism, the court must act with caution and proper restraint. It needs to be remembered, courts cannot run the government, acts as alarm bell. Recently, you can see in Rajesh Sharma versus State of Uttar Pradesh, where the Supreme Court directed the government to establish family welfare committees by district legal service authorities in case of dowry harassment cases. And the other case is where the Supreme Court, when cancelled 122 telecom license on the ground that the process of allocation was flawed. And recently, you have seen in state of Tamil Nadu versus Balu, where the Supreme Court banned liquor shops within 500 meters of highways. These three judgments recently attracted the public criticism, saying that judiciary is entering into a legislative domain. So, while concluding my lecture, no doubt judiciary can make certain laws. There is no denying fact that judges are playing an unprecedented governing role in our democratic system. It is almost difficult to think of a single issue of public policy where the court has not intervened in recent times, ranging from closure of bars on highways, striking down the ban on dance bars, regulating BCCI, so many things. However, such judicial interventions can be considered successful when there is vacuum in law and to achieve the goals specified in the preamble and to implement the rule of law. In view of this, the court must exercise their powers with great care and caution. Thank you, Sampatji. Thank you with my brief lecture on this judicial legislation and separation of powers. Thank you once again for giving me this opportunity.
Wonderful and detailed explanation about this particular subject. It's a very hot subject in India. Many lawyers and politicians and the parliamentarian and the public is talking about the judicial intervention as well as the legislative powers, many other things. You've given a lot of examples and case laws and other things. It is useful for the many advocates and students and many other persons to know what is going on between judiciary and legislative powers. Thank you, sir. You've given a lot of pain.
Thank you.
Speech from Delhi, sitting in a very comfortable post and giving an open talk about this particular subject. Now I'm requesting Mr. P. Wilson, Member of Parliament, Senior Advocate, and former Additional Solicitor General of India, will present a speech on virtual court and judicial administration. Mr. Wilson?
Yes.
Yes.
Can you hear me? Can you
Yes.
see me?
Yes, yes, yes.
Yes. Good
Yes.
evening to you all.
Your face
Thank
is
you.
not, yes, you have to correct your camera a little bit.
Can you see me?
No, it's still half of the face only. Book rack, you show your face more, it will be good.
Now?
Yes, now it's at least okay. Okay, you can give a speech.
Is it okay?
Okay,
Yes.
okay.
Good evening to you all. I thank Mr. Sampath for inviting me to give this lecture on this 28th Sattakadir Global Conference on Law and Justice. There are 5 speakers behind me, so I know time is more precious. This topic which I am going to speak today is on virtual court and judicial administration. You all know this global pandemic has compelled the Indian judiciary to devise new ways to ensure that the constitutional responsibility of justice dispensation continues. The virtual courts, which has been devised due to this sudden global pandemic, really puts us in a difficult situation. No doubt that physical court cannot be a real substitute to this virtual court hearings, but we have to live up to the present timings. In fact, the judiciary intends to realize the strength of technological advancement as a potent tool, both for ensuring access to justice in the times of need and to reduce the burden of the pending cases. We had brought out a report, the standing committee, the parliamentary standing committee, the department related standing committee on personal, public grievance, law and justice has brought out a report number 103 on the functioning of the virtual courts proceedings through the video conference. This is an interim report. In fact, this report was presented to our Honorable Vice President of India, who is also a chairman of Rajya Sabha, and the report was tabled on last session before the Rajya Sabha, and it was accepted by the Parliament. Here in this report, we have defined the court as a service. You all know we were obsessed with the fact that court is a place, but we have defined this court as a service, even though there is no definition exactly what do you mean by court, but except in Evidence Act, it says court includes all judges and magistrate and all persons except arbitrators legally authorized to take evidence, and section 20 IPC defines court of justice as a judge who is empowered by law to act judicially alone, or a body of judges which is empowered by law to act judicially as a body when such judge or a body of judges is acting judicially. So therefore, we had come to a conclusion that court is a service, and therefore the court cannot be restricted or a narrow interpretation be given that it is a place where the justice has to be delivered. A judge can sit at his residence and dispense the justice. A judge can sit in his office and dispense justice. A judge can sit in the court and dispense the justice. And that's why we have defined the court as a service. Now, the Supreme Court, which is sensitive to this global pandemic, and at the same time it wanted to deliver justice, so it has laid down certain guidelines on 6th of April 2020. The Supreme Court has recently, in the month of April, has laid down guidelines on the use of technology by courts at all levels in the hierarchy to respond to the call of social distancing. The court made observations to the effect of building capacities and capabilities to determine the modalities which would enable the transition towards the use of video conferencing technologies. The court also reflected on the prospect of institutionalizing technology in the court processes for a futuristic perspective. This COVID-19, which is not only played havoc in the lives of the people all over the world, but also has great impact in the business and also in the justice dispensation. Now, this virus, attacks among the congregation of people, and nobody can predict where the virus is lurking around or who the carrier is. With many carriers having found to be asymptomatic, usage of mask and social distancing has become mandatory and a way of life. Today, the world has adopted to this new scenario, and economic activities in the corporate world are being conducted by working from home, conduct meetings through Skype and conferences by webinar and Zoom. Even though the courts have stopped advocates from coming to court, important matters of affecting life and liberty of citizens have to be adjudicated by the courts. Therefore, the courts have come out with this new concept of virtual hearings. Now, even though we had difficulties as to how to make the concept of virtual hearings alive, because we have a lot of limitations under the Constitution, under the CRPC, under the Code of Civil Procedure. In fact, there were devil's advocates' argument that whatever the conduct of proceedings through virtual court are not legally valid. The people were saying, of course, the advocates were even saying that virtual court is illegal. They went to the extent of quoting Article 145(4), saying that no judgment could be delivered except in open court. They even relied upon Section 327 of Criminal Procedure Code, and they said that everything should be done in open court. They even went to the extent of quoting Section 153B of Civil Procedure Code and said that all hearings should be in open court. So therefore, we had difficulties with regard to conducting the cases through virtually. And Supreme Court felt that there should not be any illegality in these procedures, and therefore they gave directions to frame procedures or frame rules to deal with the open courts. Madras High Court, I would only appreciate Madras High Court because they are leader insofar as these types of innovative methods, even for digitalization of all the documents, converting into as electronic records. Madras High Court stood first under the leadership of our Chief Justice A.P. Sahi. The Madras High Court is a pioneer in standing up to the call of the virtual court hearings. In fact, way back in January 2019 itself, the Madras High Court has issued a rule called as the Madras High Court Video Conferencing Rules 2018 for the courts under the jurisdiction of Madras High Court. This rule 2018 was published in January 2019, and they started dealing with initially prisoner trials and the other similar system of the criminal where the accused were made available at one point called as remote point, and the proceedings took place in another point called as court point. After this rules were framed, after the Supreme Court direction, the Madras High Court has framed a new rules called as Madras High Court Video Conferencing in Court Rules 2020, and this rule was published on 15th July 2020. Now, one has to understand how this virtual court is going ahead. It is difficult for the advocates now to go to the court. Physical courts, of course, have been opened now. There is no second thought about that. Physical court is a best effective court. But in the present scenario, where the social distancing is sought to be maintained, where overcrowding is sought to be reduced, and where the entry and exit inside the court itself is found to be very difficult, the lawyers and litigants opt for this virtual court hearings. In virtual court hearings, one need not go physically to the court. The judge comes by way of online, and all the system is through by way of virtual court hearings. But even the filing is done through an email, and of course the physical copies are delivered at the registry, and this physical copy is made available to the judge, and to the other side it is sent through email and through online. So this new system is not fully replacing the traditional court. These smart courts are really a boon at this pandemic time. Of course, there are a lot of problems in technical glitches. There are a lot of disruptions. In fact, there is less connectivity, and there is no uninterrupted power supply, and the quality of the video and the quality of the audio is also not up to the mark. But in this pandemic time, to dispense the justice, the court had no other option than to go for this technology through virtual court hearings. The seamless video conferencing is not expected, is not up to the mark as to the expected mark, but this digital justice has to be delivered at this juncture. So therefore, the court came out with various apps. Originally, they had a Zoom, they had a video apps, then Cisco, and now we go to this Microsoft applications. This ingenious software to handle this virtual court hearings are being invented, and of course are being used where we are attempting to have a live streaming of court proceedings. This virtual courts is going to be a boon. It is going to have a different era insofar as the delivery of justice is concerned. As my earlier speaker said, access to justice is a fundamental right. So during pandemic time, the courts cannot be shut. The doors have to be kept open. There is a Latin maxim saying that even if the heavens fall down, the justice will be delivered. Even when the pandemic is there, the court remained open and it never closed. I still remember when initial period of pandemic time, I had to necessarily get an order of a stay, even though there was a pandemic, but still the administrative orders were issued, and therefore I had to move the court. I still remember I called the learned judge and the registry, and over phone the justice was delivered and an order of stay was granted. That's how the court was functioning even during pandemic time. Now, this virtual courts, how it is going to help us. In fact, in our report, in report number 103, which I have said, the committee summoned the registrar from Supreme Court. It heard the views of the bar, particularly from all the bars across the country, and it heard the views of the Bar Council chairman from Bar Council and also other advocates. Now, what we feel from the hearing after hearing of all the concern is that though the technology has not developed to that extent, certainly we can feel the technology glitch where a lot of disruptions are there at the time of hearing. So we felt that the technology, the bandwidth has to be increased, and the technology has to be improved, and the connectivity should also be improved. We also found that many lawyers who are not adapted to this switch over of technology, and we advised in our report that the Bar Council, they have to educate these young budding lawyers who doesn't have enough infrastructure, enough sources. They can be at least classes can be taken for these lawyers, how to handle these computers, how to handle this virtual court. That was the suggestion given in the report. And even the Bar Council could also give the financial assistance to the lawyers who can, at the initial stage, who are not able to purchase this laptops or computers. They can also have the opportunity of joining this digital justice delivery system. And we have also suggested in that report that the Bar Council can introduce a course in this 5 years course or 3 years course, one subject relating to this computer, so that the young law graduates, while pass out from the colleges, they will be adapted to this technology. And these are all the suggestions which you have given. Now, how far this virtual court is going to really help us? One, I told how during pandemic time has really helped us. The dispensation of justice and the fundamental rights cannot be suspended. Article 19, Article 21, Article 14. Certainly, these constitutional rights at no point of time can be kept in abeyance. We had heard that during emergency period it was suspended, and we had seen how the court have dealt with those situations. Therefore, this virtual court hearings, we have suggested it can be made permanent insofar as the tribunals are concerned. Take, for example, the tribunal located in Delhi. There are a lot of tribunals located in Delhi, like the PMLA tribunals, like the TDSAT, like some of important tribunals that is located in Delhi. We have some tribunals in Chennai also, like IPAB, Intellectual Property Appellate Board, where the principal office is in Chennai, the principal seat is in Chennai. So these tribunals, where it is located all over India, we have suggested that we can have a permanent the virtual court hearings for these types of tribunals. So a lawyer need not travel all the way from Chennai to Delhi, or the lawyer who is situated in Delhi need not come to IPAP at Chennai. They can simply log on and they can complete the hearing, and the tribunal can also hear them by this virtual court hearing. So this dispensation of justice can be done through virtual court hearings so far as the tribunals are concerned. This is the suggestions which you have given. Even we have even suggested that when Supreme Court is going to have one even post-pandemic, continue with the virtual court hearings. The question of the benches of Supreme Court, regional benches of Supreme Court, which has been a long pending demand, that can be met. For example, we can sit in Chennai and argue a case in Supreme Court. We need not go to Supreme Court. So a lawyer whose case is now taken to Supreme Court, who has argued before the Madras High Court, and the client is interested in engaging him even in the Supreme Court because he is well aware about the facts, who is well aware about all the details of that case, he can sit at his office and he can argue this matter. So we had suggested post-pandemic, let some cases, some courts can continue with this on a trial and error methods. If this is going to be continued as a trial and error method, certainly the stakeholders, namely the lawyers, the litigants, and the other persons also who are interested in this litigation will be more benefited. We have also found that this virtual court hearings is going to reduce the rush towards the court. It will save fuel, it will save space, it will save persons coming to the court and the courts being flooded with the lawyers and litigants. So this virtual court hearings, if it is going to be continued post-pandemic as a temporary measure and made it to be permanent based upon how it works, certainly this new virtual court hearings would clearly explain how it is going to be benefited for the litigant. In fact, our Madras High Court has, by these rules, as I said, it's a pioneer which has framed the rules. It has even gone to the extent of the trials, applying these rules for trial. Even the trial works have now started. I am informed that the witnesses' examination, cross-examination are being done virtually. So this benefit is not only going to be passed on for the appellate side works, but also to the original side works. The lower courts are now equipped with this infrastructure. Each court is now equipped with this infrastructure. Certainly, all the trials and hearings in the subordinate courts and even district courts are going to be utilized, and therefore this virtual court is certainly is going to become an integral part of justice dispensation. So we had advised this arbitration matters where you can the conciliation. These are all areas where you can have a virtual court hearings. Maybe the lawyers, the assisting counsel will have a difficulty in contacting the arguing counsel during the course of hearing. But we have to adopt to these technology. Only when we adopt to these technology, otherwise we will lose. We will not be in a position to compete with the world. Now this virtual court hearings is maybe new so far as the pandemic time, so far as our country is concerned. But if you take the countries like USA, UK, then France, Italy, Germany, China, Canada, Australia, they have at some point of time already adopted this virtual court hearings. In fact, in UK, they say that there is a link between the court and the police station, and one need not come to the court physically for these hearings, and that is how this has been followed in other countries. So this people now should adopt to this new technology. In fact, the lawyers should also come out, to have this method worked out. Maybe this there is a data privacy and data security in these issues. But these all have to be sorted out, and we have to adopt to this new technology, and the lawyers should accept that this pandemic time, where this virtual court hearings has really helped us. No doubt that this cannot be a substitute to the physical court hearings, but we cannot forget that during a pandemic time, it has really helped us, and we have able to do our work, perform our profession even during pandemic time because of this virtual court hearings. Therefore, I would say that virtual courts has really helped in the justice dispensation, and the full-fledged virtual course should be piloted, and even after post-pandemic in some areas, as I suggested, that the appellate side works, like where the presence of a lawyer in the court is not required. He can save the time. He can also save the court's timings in seeking adjournments. When he is ready, then the virtual court hearings, he can present his case, and he can argue the matters, the appeals before the court, and the other side also can make himself convenient for these hearings. So that is how we plan our judicial timings, because it's a valuable one, and therefore we can plan ourselves. We can, in fact, I feel a day may come that the robot justice started now being delivered. You all would have heard. What do you mean by this robot justice? This is like a challan, being generated. If you tell the offense, the robot itself will deliver the justice. The violation is once entered, then the robot writes the judgment, it writes the challan, and it gives the judgment. This is, in fact, implemented in the motor vehicles cases, where the fines and penalties are being implemented. In this way, we have to take forward the virtual court hearings. I'm not here to say that it has to replace completely the physical court hearings, but we should adopt ourselves to the technology. I would only recall as to how those days we have seen gramophones. We had a very big disc. Then it was replaced by tape recorders. We can see a small tape running. Then it was replaced by iPods, and today we have Apple phones and other phones. We hear the music. Likewise, we went to the bank to receive the money, and thereafter we are using the ATM cards, and now we are doing online. So we are adopting to the technology. So when we adopt to the technology, why not adopt to the virtual court hearings? After all, the justice has to be dispensed with, the justice dispensation has to be done, and the justice has to be delivered, and we are the part of the system, and certainly we should rise to all these difficulties, and we should also perform our duties during this pandemic time. Sir, I thank you very much for giving me an opportunity to explain about the virtual court hearings, and thank you very much.
Thank you, Mr. Wilson. You've given a very detailed speech, more than 30 minutes. Anyway, I'm requesting other participants to control the speech for 15 minutes because you've given a lot of example and a lot of usage for this virtual court. But many lawyers telling personally to me also, I'm waiting for the actually physical court to appear before and convince the judge. Because of virtual court, we are unable to argue more and also to finish up like so quickly. That is why we are unable to take the law properly. That is the one argument going on all over the world. I have participated in many board meetings in the different corporate companies. They used to organize for video conferencing only if it is necessary. Otherwise, they used to organize physical board of director meeting. Similarly, we need for virtual court or lot of cases, and also we need for physical court also. Then only it will be more useful for to present the explanation about the scope of law and the scope of the case. Thank you. Thank you. And now I am requesting Mr. Dr. A. Thiagarajan, Senior Advocate, Madras High Court, present his speech on media trial and court trial. It's a very important burning subject now. I'm requesting Dr. Thiagarajan. Thiagarajan?
Good evening, sir.
Okay, you can talk.
Good evening. Audible?
Yes, yes.
Good evening to everyone. I am thankful to Dr. Sambat. Sambat?
Yes, I'm listening. Your talk.
Okay.
Because if everybody talking like that, replying for each question,
Okay.
conference, virtual conference, not easy to. Because when you are asking question one by one, good evening, then it will disturb. You talk directly. If any issue, we'll call you.
Honorable Justice Kalayarasan, Honorable Justice Gopal Gowda, Dr. G. Viswanathan, Dr. R. Narayan Raju, Mr. P. Wilson, MP and Senior Advocate, Srikanth Raja, Professor Raghunath Reddy, Prem Raja, and Meenakshi Sundaram. Good evening to everyone. The topic today given to me is trial by media and trial in court. So trial by media has no statutory authority or legal sanction to conduct a trial, which we can call it as extrajudicial method, which is not recognized by the law and courts. The freedom of speech and expression, as contemplated under Article 19(1)(a) of the Constitution of India, has its restrictions in Article 19(2). So the very concept of freedom of speech and expression has been coined somewhere in 2015 in the Magna Carta, where no free man shall be taken or retained except by legal jurisprudence within the spheres of law or by law. So there started the freedom of man, which now we call it as fundamental rights. The Bills of Rights of the American Constitution is equal to Part 3 of the Constitution of India. Now, we all know and we have been taught that pen is mightier than sword. Pen is more powerful than a sword. The word pen is mightier than sword was coined by E.B. Lytton. He coined these words to use his drama that has become a very wonderful adage which has been used in all the dictionaries, and even Woodrow Wilson used this as a election manifesto And that was the word, pen is mightier than sword, has come into existence. So now these writings, speech made by an individual, disseminated by way of written articles or placed in newspaper or in TV or in any media, whether has any legal sanction or background. So as I said, Article 19(1)(a) gives freedom of speech and expression, which includes press and media, and ultimately the expression of individual about their thought, their feelings, their understanding and interpretation will definitely protected by the law, provided it is within the restriction given under the Constitution. Therefore, Article 19(1)(a) gives freedom of speech and expression, and how the freedom of speech and expression is controlled by law as contemplated under the Constitution of India. So, Article 21 of the Constitution of India uses the word except according to procedure established by law. So, the procedure established by law is a basis for each and every act. The Professor Dr. Narayan Raju was referring to due process of law and the procedure established by law, how we have adopted this procedure established by law. So that subtle difference between the due process of law and the procedure established by law is, for the due process of law, the procedure or rules and regulations framed must have a reasonable basis for such procedure. That was the due process of law. Whereas in the case of, according to procedure established by law under the Indian Constitution, there need not be any reasonable basis or reason for such a procedure contemplated under law. So this is a vital difference between the due process of law and procedure established by law. Now, from Maneka Gandhi case onwards, the Honorable Supreme Court of India has interpreted the due process of law and applied the procedure established by law wherever it is permissible under the facts and circumstances of the case. This was the case in the Maneka Gandhi case, and in Raj Narayan with the state of UP, the procedure established by law has been interpreted by the Supreme Court of India and applied the due process of law by extending the principles of the procedure established under the law. So therefore, applying these principles for each and every act in a criminal court, proceedings are based on the Criminal Procedure Code. Whereas conducting the media trial, they don't have any procedure or even they don't have any legal sanction at all. The concept of freedom of expression and press or any media is restricted only to whatever emanated. Say, for example, an FIR has been registered. They can only say why FIR number so and so allegations are made. That was not a conclusive proof of a case, because FIR is only an information, set the law in motion. Thereafter, various procedure have been contemplated for the investigating authorities to follow. The right to defend has been given to the accused, for which the accused are vested with the right under Article 20, 21, 22 of the Constitution of India. Based on these principles, persons can be detained. A preventive detention can be made following the procedure, limiting the period of detention and giving liberty to the individual to challenge the detention before the advisory board and also before the Honorable Supreme Court or High Court on Article 32 or 22, 23, depending upon the circumstances of the case. So therefore, the procedure contemplated under the law in a court of law is based on the legal authority. Simply a person cannot be arrested. And now the Supreme Court have held that are flimsy cases and even cases where the punishment is not more than 7 years, the accused need not be arrested. Therefore, whenever any person is arrested now, immediately the media takes up the matter and publish the newspaper with photographs, forgetting the fact there are restrictions disclosing the name of the victims and particularly offences relating to women and children. They would forget all the legal bar. They discuss openly. Sometimes in pseudonym they also discuss, which is all totally prohibited. And such maligning the character of a person who faces only acquisition, not come to a complete trial or come to a conclusion by a judge, creates an impression in the mind of the public. So that is why I said, when is mightier than sword. When a newspaper publishes about a case and narrates or discuss in the TV, people will come to a conclusion the particular person has committed the offense. They found him guilty. Public sentence him as if he is found guilty, forgetting the fact that law presume all the person who has been either arrested or an FIR is registered to be innocent, unless it is proved beyond reasonable doubt in a court of law by a competent court of law. So therefore, a person who simply because alleged to have committed an offense or arrested or remanded will not come to a conclusion that he has committed the offense. Even for arresting a person, a male, senior citizen, women and children, law prohibits and gives a procedure, what are the procedure to be followed by the investigating authorities or police authorities. And in sexual offenses, they are not supposed to divulge the name of the victim and photographs. If those things are divulged, their right to life, decency, and privacy, everything has gone to public. Nobody can restore it. Ultimately, the offense is either proved or disproved, that has to be declared only by the competent court, not by media. So we have come across so many cases. The media decides or publishes or discuss, creating an impression that a particular person has committed the offense. But ultimately, the court acquit the person. Then agitation starts saying that the courts have convicted or acquitted the person erroneously or something like that. I have seen some of the cases, the possessions have been taken out. See, there was a case in Chidambaram police custody. The lady was involved in that case. They were convicted. Appeal has been filed in the High Court. The High Court has granted bail. It is pending appeal. It is the discretion of the court to consider the circumstances of the case, likelihood of taking up the case at the earliest point of time, pendency of cases. The High Court has suspended the sentence. Immediately, a procession has been taken out. And the very next week, the court has cancelled the bail. So, the point which I wanted to submit is, before a court takes a decision, or when the matter is pending before the decision, if any discussion is taken place outside the court, we can call it as an extrajudicial discussion, extrajudicial act, which definitely interfere in the minds of the proceeding officer and also in the minds of the public. We cannot erase the impression created in the minds of the public. We cannot go to each and every person and explain what the court has dealt with. Say, for example, in a court of law, the burden of proof is the most important factor. In civil cases, the burden of proof is different. In criminal cases, the burden of proof is different. And in quasi-criminal cases, the burden of proof is totally different. So the burden of proof in criminal cases is always static. The prosecution has to prove the case beyond reasonable doubt, except cases where the accused admit the act and he pleads not an offense, or the burden of proof is on the accused by the statute by itself. Similarly, in civil cases, the burden of proof is shifting from one person to another person, a plaintiff to the defendant and defendant to the plaintiff. And in quasi-criminal cases, quasi-judicial cases like Customs Act, Income Tax Act, those cases, prima facie case has to be made out by the prosecution. The burden will be then shifted to the accused. And there are stages where the accused have been given right to defend his case. When an FIR has been registered, the accused has every right to move a bail application. Nowadays, every bail application is supposed by interveners. That means they are not believing the prosecution. Next stage, the accused has every right to challenge that FIR also, making out there was no case against him. Secondly, after filing the charge sheet, the accused has every right to file a discharge petition. Even after that, the accused has a right to go to the High Court. During trial also, the accused has every right to cross-examine the witnesses, demolish the witnesses, the evidences, and the character of the witness. So ultimately, the accused has so many stages to defend his case. Even before that, if the media come to a conclusion that the person has committed the offense, then there is no end for that. Not only the statute provides fundamental right to the accused, also protect the interests of the victim. Now, by section 357 A, B, C, that various methods have been adopted for compensating the victim. And therefore, the procedure established by law is protect the victim, give liberty or right to the accused to defend his case to establish innocence, give right to the prosecution to prove the case. In such a scenario, the procedure contemplated under the Constitution and other various statutes like Criminal Procedure Code, Evidence Act, other acts, the media trial is outside the purview of law. And the courts have every right to call for opinion evidence or expert evidence whenever it is required by law or required by the court to form any opinion. To form an opinion, the courts have every right to call for expert opinion, and the medical legal cases, expert opinions, medical jurisprudence, and other technical assistance to the court is very much available under law. Therefore, the procedure followed by the court of law has been now interfered by the media, which has been disapproved by the Honorable Supreme Court of India in the case of Manu Sharma versus State of New Delhi Union Territory. I will read 2 paragraphs for the purpose of the audience about the decision made by the Supreme Court. There is a danger of serious risk of prejudice if the media exercise an unrestricted and unregulated freedom such that it publishes photographs of the suspects or the accused before the identification period are constituted, or if the media publishes statements which outrightly hold the suspect or the accused guilty even before such an order has been passed by the court. Despite the significance of the print and electronic media, the present day, it's not only desirable, but least that is expected of the persons at the helm of affairs in the field to ensure that the trial by media does not hamper fair investigation by the investigating agency, and more importantly, does not prejudice the right of the defense of the accused in any manner whatsoever. It will amount to travesty of justice if either of these cause impediments in the accepted judicious and fair investigation and the trial. The present case, certain articles and news items appeared in the newspaper immediately after the date of occurrence did cause certain confusion in the mind of the public as to their description and number of the actual assailant suspects. It is unfortunate that the trial by media did, though to a very limited extent, affected the accused, but not tantamount to a prejudice which should weigh with the court taking any different view. The freedom of speech protected under Article 19(1)(a) of the Constitution of India has to be carefully and cautiously used so as to avoid interference with the administration of justice and leading to undesirable result in the matter of sub judice before the courts. Therefore, the Honorable Supreme Court of India has disapproved this kind of media trial and has given a clear-cut finding what the media should follow. I think I have completed to an extent. I thank Mr. V.R. Sambat for giving me this opportunity, and I circulate the articles which I have written. If I complete the article, it will take more than 1 hour. So due to the paucity of time, I conclude my speech. I thank Mr. Sambat and audience have given a very patient hearing to the lecture. Thank you very much.
Thank you, Mr. Dr. Thiagarajan, you have a detailed speech on that, even though you want a 1 hour time. We can take that paper and then we can include in our publication. It is a very crucial topic going on, discussion from all over India. Because of the print media, not only print media, now is the electronic media, television, many news television, doing regular media trial for many cases. It is affecting the court proceedings very badly. It is very important to talk elaborately in many lawyers and judges together in the big seminar. I'm sincere thanks to your presentation. Now our chief guest is arrived, Honorable Justice Mr. Gopal Gowda from the retired judge of the Supreme Court of India. He's a wonderful judge and he's a progressive judge. He given a lot of judgment in very progressively. He's a wonderful speaker also. He was there last year when we were together in the Madurai seminar. All the lawyers enjoyed his speech because of his year. He can deliver his presidential as well as the chief guest address. Now, I'm requesting his lordship to present the speech. Your lordship, just now I saw. Sir, Honorable Justice Gopal Gowda, I think, 1 minute, let's see. Anyway, I think I will call him at the end of the meeting. Now I am requesting our friend and also is a senior member of the bar, attorney from London. He's actually studied in Tamil Nadu and practiced in Colombo and Nigeria and London and many other places. He's an expert on legal drafting, and also he knows very well Tamil as well as the legal language, both together. He will give a wonderful speech from London. Sir, so you can switch you can unmute your mic. Unmute.
வணக்கம்.
Yes, you can give a speech.
எட்ட இருந்தபடியே இந்த நிகழ்ச்சியில் பங்கு பெற்றிக் கொண்டிருக்கின்ற சட்டம் வல்லார்க்கும் ஏனைய அறிஞர்களுக்கும் அன்பர்களுக்கும் பணிவன்பான வணக்கம். ஜுடிஷியல் அட்மினிஸ்ட்ரேஷன் அண்ட் தி லீகல் லாங்குவேஜ் என்ற தலைப்பில் உரையாற்றுமாறு என் இனிய நண்பர் முனைவர் வி.ஆர்.எஸ். சம்பத் அவர்கள் என்னை வேண்டியிருக்கிறார். அதற்காக அவருக்கு நான் நன்றி கூறி வாழ்த்துகிறேன். பெறப்பட்ட தலைப்பினை தமிழிலே மொழிபெயர்த்தால் நீதி நிர்வாகமும் சட்ட மொழியும் என்று ஆகும். மொழிபெயர்க்கப்பட்ட தமிழ் தொடரில் வருகின்ற சட்ட மொழி என்ற சொல் சட்ட ஆக்க மொழி அல்லது வழக்குரை மொழி என்ற பொருளில் கொடுக்கப்பட்டிருக்கிறது என்ற அடிப்படையில் சில கருத்துக்களை கூற விளைகின்றேன். 35 ஆண்டுகளுக்கு மேலாக இலண்டனில் அரசாங்க துறையிலும் தனியார் துறையிலும் சட்ட தொழில் புரிந்த இலங்கை தமிழன் என்ற முறையிலும் இலங்கையில் வாழ்ந்த காலத்தில் நீதி அமைச்சின் கீழான சட்ட வரைஞர் திணைக்களத்தில் 20 ஆண்டுகள் சட்ட மூலங்களை வரைபவனாகவும் அவ்வாறு வரையப்பட்ட சட்ட மூலங்களை, அதாவது பில்ஸ் எனப்படுகின்றவற்றை தமிழில் மொழிபெயர்த்தவன் என்ற முறையிலும் இலங்கையின் 1972 ஆண்டின் அரசியல் அமைப்பு சட்டத்தையும் 1978 ஆண்டின் J.R. ஜெயவர்தனா புதுக்கி அமைத்த அரசியல் அமைப்பு சட்டத்தையும் மொழிபெயர்த்தவன் என்ற வகையிலும் எனக்கு கொடுக்கப்பட்ட தலைப்பில் பேசுவதற்கு முன் வந்திருக்கிறேன். Necessity is the mother of invention என்ற ஒரு ஆங்கில தொடர் எல்லோருக்கும் தெரிந்த ஒன்று. கல்வித்துறையிலும் சட்டத்துறையிலும் நீதி நிர்வாகத் துறையிலும் இலங்கை தமிழர் இதன் பொருளை நன்றாகவே புரிந்திருக்கிறார்கள் என்று சொல்லலாம். நீதி நிர்வாகம் என்று பேச நேர்ந்து விட்டால் இலங்கை தமிழர் தமிழ்நாட்டு தமிழரை விட வாய்ப்பான ஒரு நிலையில் இருக்கிறார்கள் என்று சொல்லலாம். நடைமுறையில் இல்லாவிட்டாலும் சட்ட அளவிலாகுதல் வாய்ப்பான ஒரு நிலையில் இருக்கிறார்கள் என்று சொல்லலாம். இலங்கை சுதந்திரம் பெற்றதன் பின்னர், அதாவது 1948 ஆண்டிற்கு பின்னர் இலங்கையில் நிலவிய அரசியல் சூழல் அத்தகைய ஒரு வாய்ப்பை இலங்கை தமிழருக்கு தந்தது என்று சொல்லலாம். தந்தது என்பது சரியன்று, வந்தது என்பதே சரி. நெல்லுக்கு இறைத்த நீர் வழியிலே புல்லுக்கும் கசிந்தது. குறுக்கு வழியிலே குறுகிய ஒரு காலத்துக்குள்ளே அரசியல் லாபம் பெற்று பிரதம மந்திரியாகி விட வேண்டும் என்று அங்கலாய்த்த SWRD பண்டாரநாயக்க ஸ்ரீலங்கா சுதந்திர கட்சி என்ற ஒரு அரசியல் கட்சியத்தை திடுதிப்பென தொடங்கி தம்மை ஆட்சி பீடத்தில் ஏற்றி இலங்கை பிரதமராக்கினால் தமது சம உரிமை கொள்கையை ஆள புதைத்துவிட்டு 24 மணி நேரத்தில் சிங்கள மொழியை ஆட்சி மன்ற மொழியாகவும் நீதிமன்ற மொழியாகவும் ஆக்குவேன் என்று கூறி அரசியல் பரப்புரை செய்தார். அந்த பரப்புரையால் ஆட்சி பீடமேறிய பண்டாரநாயக்கா பிரதமரானதும் தமது வாக்குறுதியை நிறைவேற்றி 1986 ஆண்டில் தி ஆபிஷியல் லாங்குவேஜ் ஆக்ட் என்ற ஒரு சட்டத்தை இயற்றினார். தமிழர்கள் இந்த சட்டத்தை எதிர்த்து கிளர்ந்த போது அவர்களை தற்காலிகமாக சமாளிக்கின்ற வகையில் தமிழ் லாங்குவேஜ் ஸ்பெஷல் ப்ரொவிஷன்ஸ் ஆக்ட் என்ற ஒரு சட்டத்தை 2 ஆண்டுக்குள் இயற்றி நிறைவேற்றினார். ஆபிஷியல் லாங்குவேஜ் ஆக்ட் என்பதை அரச கரும மொழி சட்டம் என்று மொழிபெயர்த்திருக்கிறோம். சிங்களம்தான் அரச கரும மொழி சட்டம் என்று சட்டத்தை மட்டும் இயற்றினால் போதுமா? அரச கருமம் என்பது ஆளும் அரசாங்கத்தின் ஆட்சி கருமங்கள் மட்டுமா? கல்வி மொழி, பள்ளி மொழி, கல்லூரி மொழி, பல்கலைக்கழக மொழி, நீதிமன்ற மொழி, சட்டக்கல்லூரி மொழி, தொழில்நுட்ப கல்லூரி மொழி, மருத்துவ கல்லூரி மொழி என்று இவை அனைத்தும் அரச கரும மொழி என்ற தொடரில் அடங்கும். பாராளுமன்ற பெரும்பான்மை இருந்ததால் இட்டப்படி அரச கர்ம மொழி சட்டம் இயற்றி ஆயிற்று. ஆனால் இவற்றை நடைமுறைப்படுத்துவது எப்படி என்ற கேள்வி பூதாகரமாக பண்டாரநாயக்காவின் வீட்டு வாசலில் காத்து நின்றது. அரச கருமங்களை நடத்துவதற்கு வேண்டிய சிங்கள சொற்களுக்கு எங்கே போவது? அவ்வாறு தமிழ் சொற்களுக்கு எங்கே போவது? சட்ட கல்விக்கான சொற்களுக்கு எங்கே போவது? மருத்துவ கல்விக்கான சொற்களுக்கு எங்கே போவது? தேவை முடுக்கியது. அவசரமும் அவசியமும் முடுக்கின. யோசித்து பயனில்லை. சொல்லாக்க பணியின் நூலாக்க பணியும் உடனடியாக மேற்கொள்ளப்பட வேண்டும் என்பதை பண்டாரநாயக்கா உணர்ந்தார். நெசசிட்டி இஸ் த மதர் ஆஃப் இன்வென்ஷன் என்பதன் தத்துவார்த்தத்தை அவர் புரிந்தார். இதன் விளைவுதான் ஆபிஷியல் லாங்குவேஜ் டிபார்ட்மெண்ட் என்ற அமைப்பு, அதாவது அரச கரும மொழி திணைக்களம் இந்த திணைக்களம் பலதரப்பட்ட சொல்லாக்க குழுக்களையும் பாடநூல் குழுக்களையும் எழுதுனர் குழுக்களையும் உருவாக்கி கலைச்சொற்களையும் விஞ்ஞான நூல்களையும் படைக்கின்ற பணியில் இறங்கியது. ஏறத்தாழ 15 ஆண்டு காலத்துக்குள் அரச கரும திணைக்களத்தினர் 60க்கு மேற்பட்ட கலைச்சொற் தொகுதிகளையும் 500க்கு மேற்பட்ட பாடநூல்களையும் படைத்து குவித்தார்கள். இலங்கைக்கு ஏற்பட்டது போன்ற ஒரு நெசசிட்டி தமிழ்நாட்டு தமிழருக்கு ஏற்படவில்லை. அதனால் சட்ட சொல்லாக்க தொகுதிகள் என்ற இன்வென்ஷனுக்கு புதியன படைத்தலுக்கு வாய்ப்பில்லாது போயிற்று. தமிழ்நாட்டில் அவசியமும் அவசரமும் அவர்களை முடுக்கவில்லை. அவர்கள் ஆமை வேகத்தில் மட்டுமே நகர்ந்தார்கள். சட்ட தேவைகளுக்கோ மருத்துவ தேவைகளுக்கோ வேண்டிய எல்லாவற்றையும் இலங்கையில் படைத்து விட்டார்கள் என்று சொல்ல நான் முன்வரவில்லை. ஆனால் கல்வியானது எல்லா நிலையிலும் எல்லா மட்டத்திலும் சுயபாசையில், அதாவது தன்மொழியில் பயிற்றப்பட வேண்டும் என்ற கண்டிப்பான சட்டம் இருக்கிறது இலங்கையில். நீதி நிர்வாகம் சிங்களத்திலும் தமிழில் நடத்தப்பட வேண்டும் என்ற கட்டாயம் இருக்கிறது இலங்கையில். சட்டத்துறையில் நாம் அடிக்கடி சொல்வோமே, எவ்ரி லா ஹஸ் an exception என்று. நான் மேற்கூறிய சட்டங்களிலும் பல ப்ரோவைசோக்கள் உண்டு. லா must be a living thing, it must be flexible என்பார்களே, அப்படியான பிளெக்சிபிலிட்டியை நெகிழ்ச்சியை கொடுப்பவைதான் மேற்படி ப்ரோவைசோக்கள். கல்வித்துறையிலும் சட்டத்துறையிலும் இலங்கையில் பலவிதமான பரீட்சார்த்தங்கள் ட்ரையல்ஸ் நடைபெற்றுக் கொண்டிருக்கின்றன. இலங்கையில் இப்போது சட்டங்கள் எல்லாம் சிங்களத்தில் வரையப்பட்டும் இயற்றப்பட்டும் தமிழிலும் ஆங்கிலத்திலும் உடனேயே சமகாலத்தில் மொழிபெயர்க்கப்படுகின்றன. தேவை ஏற்படும் போதில் அவை ஆங்கிலத்தில் வரையப்பட்டு சிங்களத்திலும் தமிழிலும் மொழிபெயர்க்கப்படுகின்றன. குறிப்பாக 1972ஆம் ஆண்டின் அரசியலமைப்பு சட்டம் இயற்றப்பட்டதன் பின்னர் இயற்றப்பட்ட செய்யப்பட்ட எல்லா சட்டங்களும் இன்று 3 மொழிகளிலும் உள்ளன. 1933ஆம் ஆண்டிற்கு பின்னர் இலங்கையில் இயற்றப்பட்ட முக்கியமான சட்டங்களில் பெரும்பாலானவை சிங்களத்திலும் தமிழிலும் மொழிபெயர்க்கப்பட்டு விட்டன. இவ்வாறு மொழிபெயர்ப்பதற்கான தேவை ஒன்று இருந்தது அங்கே. அந்த தேவையை 1972ஆம் ஆண்டின் அரசியலமைப்பு சட்டம் அவசியமாக்கி இருந்தது, கட்டாயமாக்கி இருந்தது. சம்பந்தப்பட்ட அந்த அரசியலமைப்பு சட்டத்தின் பிரிவுகளை எனது பேச்சை கேட்டுக் கொண்டிருக்கின்ற சட்ட அறிஞர்களுக்கு வாசித்து காட்டுவது இந்த சந்தர்ப்பத்தில் பொருத்தம் என நினைக்கிறேன். பிரதமர் ஸ்ரீமாபு பண்டார் நாயக்காவின் ஆட்சியின் தொடக்கமான 1972ஆம் ஆண்டில் இயற்றப்பட்ட அரசியலமைப்பு சட்டத்தின் 7வது உறுப்புரை பின்வருமாறு அமைந்திருக்கிறது. The official language of Sri Lanka shall be singular as provided by the Official Language Act number 33 of 1956. The use of the Tamil language shall be in accordance with the Tamil Language Special Provisions Act number 28 of 1958. அந்த அரசியலமைப்பு சட்டத்தின் 9வது உறுப்புரை பின்வருமாறு அமைந்திருக்கிறது. All laws shall be enacted or made in Sinhala. There shall be a Tamil translation of every law so enacted or made. All written laws, including subordinate legislation, in force immediately prior to the commencement of the Constitution, shall be published in the Gazette in Sinhala and in Tamil translation as expeditiously as possible under the authority of the minister in charge of the subject of justice. The law so published shall be laid before the National State Assembly at the meeting next following the date of such publication. Unless the National State Assembly otherwise provides, the law published in Sinhala under the provisions of the aforesaid shall, as from the date of such publication, shall be deemed to be the law and shall supersede the corresponding law in English. இவ்வாறு ஆங்கில மொழியில் இருந்த சட்டங்களை நீக்கிவிட்டு அவற்றின் இடத்தில் அதே ஆங்கில சட்டங்களின் சிங்கள மொழிபெயர்ப்பை அரியாசனத்தில் இருத்திய அரசியலமைப்பு சட்டம் நீதிமன்ற மொழி தொடர்பில், அதாவது கோர்ட் லாங்குவேஜ் தொடர்பில் பின்வரும் ஏற்பாடுகளை செய்தது. Article 11. The language of the courts and the tribunals empowered by law to administer justice, and of courts, tribunals, and other institutions established under the Industrial Disputes Act and the conciliation boards established under the Conciliation Boards Act of 1958 shall be in singular throughout Sri Lanka. And accordingly, their records, including pleadings, proceedings, judgments, orders, and records of all judicial and ministerial acts shall be in singular, provided. Sorry. Shall I go on? Amma.
You can go on. You can go on.
Shall I go on?
Yes, yes.
Right. Provided that the National State Assembly may, by or under its law, provide otherwise in the case of institutions exercising original jurisdiction in the northern and eastern provinces. என்று ஏற்பாடு செய்து சிங்கள மொழிக்கு அரியாசனம் தந்து தமிழ் மொழிக்கு வடக்கு கிழக்கு மாகாணங்களில் பிச்சை போடுமா போல ஏற்பாடு செய்த அரசியலமைப்பு சட்டம் அந்த பிச்சைப்படியை சற்று தாராளமாக்கி பின்வருமாறு ஏற்பாடு ஒன்றையும் செய்தது. In the northern and the eastern provinces, persons legally entitled to represent such parties or applicants may submit their pleadings, applications, and motions and petitions in the Tamil language and participate in such proceedings in Tamil. In all such cases, singular translation shall be caused to be made by such court or tribunal for the purposes of such record. மேற்கண்டவாறு அரசியலமைப்பு சட்டத்தில் ஏற்பாடு செய்யப்பட்டிருந்ததால் 1972 ஆண்டிலிருந்து இலங்கை நீதிமன்றங்களில் தமிழ் மொழியில் வழக்குரைப்பதற்கான உரிமை ஒன்று தமிழருக்கு வழங்கப்பட்டிருந்தது. இந்த வாய்ப்பை தமிழர் எவ்வளவுக்கு பயன்படுத்தினார்கள் என்பது வேறு கதை. இருப்பினும் ஒரு சில வழக்கறிஞரும் வழக்காளிகளும் வடக்கு கிழக்கில் உள்ள நீதிமன்றங்களில் தமிழ் ஒலிக்க வேண்டும் என்று முயன்றார்கள் என்பதையும் மறக்க முடியாது. இப்படியான அரசியலமைப்பு சட்ட ஏற்பாடுகளினால் தமிழை நீதிமன்ற மொழியாக அமைக்க முடியுமா என்பதை உரசி பார்ப்பதற்கான ஒரு வாய்ப்பு இலங்கை தமிழருக்கு ஏற்பட்டது. இந்த அரசியலமைப்பு சட்டம் வரையப்படுவதற்கு முன்னால் 1971 ஆண்டில் சட்டமும் தமிழும் என்ற ஒரு நூலை நான் எழுதி அதனை அக்காலத்து வழக்கறிஞர்களுக்கு அறிமுகப்படுத்தி வைத்தேன். 1972 ஆண்டில் அரசியலமைப்பு சட்டத்தின் பயனாக சட்ட மொழிபெயர்ப்பு வேலைகள் முடுக்கிவிடப்பட்டன. ஆட்சி மொழியும் நீதிமன்ற மொழியும் சிங்களம் மட்டுமே என்று ஆகிவிட்டதால் சிங்கள மொழிபெயர்ப்பு வேலைகள் முயல் வேகத்தில் நடைபெற்றன. நெல்லுக்கு இறைத்த நீர் வாய்க்கால் வழியோடி புல்லுக்கும் அங்கே பொசிந்ததால் தமிழிலும் சட்ட மொழிபெயர்ப்புகளும் சட்ட நூல் மொழிபெயர்ப்புகளும் முன்னெடுக்கப்பட்டன. 1972 ஆண்டின் அரசியலமைப்பு சட்டம் தமிழ் மொழிக்கு சரியாசனம் தரவில்லை என்று தமிழ் அரசியல்வாதிகள் வாதிட்டுக் கொண்டே வந்தார்கள். ஆனால் ஸ்ரீமாவோ பண்டார நாயக்காவின் அரசாங்கம் செவிசாய்க்கவில்லை. 1978 ஆண்டில் ஆட்சிக்கு வந்த ஜே.ஆர். ஜெயவர்தனா அவர்கள் நடப்பில் இருந்த அரசியலமைப்பு சட்டத்தை நீக்கிவிட்டு அதற்கு பதிலாக புதிய ஒரு அரசியலமைப்பு சட்டத்தை வரைந்தார். ஜெயவர்தனாவின் அரசியலமைப்பு சட்டம் பேரளவிலாகுதல் தமிழருக்கு கூடுதலான மொழி உரிமைகளை கொடுத்தது. அதற்காக இவ்வாறு அது ஏற்பாடு செய்தது. The official language of Sri Lanka shall be in singular என்று ஏற்பாடு செய்த 18ஆம் உறுப்புரை Tamil also shall be an official language என்று ஏற்பாடு செய்து English shall be the lingua language என்று ஏற்பாடு செய்தது. The national language of Sri Lanka shall be singular and Tamil என்று ஏற்பாடு செய்தது. மேற்கண்டவாறு ஏற்பாடு செய்த ஜெயவர்த்தனாவின் அரசியலமைப்பு சட்டம் சட்டவாக்கம் தொடர்பிலும் நீதி நிர்வாகம் தொடர்பிலும் பின்வரும் முக்கிய ஏற்பாடுகளை கொண்டிருந்தது. 23ஆம் உறுப்புரை பின்வருமாறு அமைந்தது. All laws and subordinate legislation shall be enacted or made and published in Sinhala and Tamil together with a translation thereof in English, provided that Parliament shall, at the stage of enactment of any law, determine which text shall prevail in the event of any inconsistency between texts. மேலே கூறியவாறு தமிழுக்கும் சிங்களத்துக்கும் ஒத்த உரிமை போன்ற போதிய உரிமையை வழங்கிய அரசியல் அமைப்பு சட்டம் வேறொரு ஏற்பாட்டையும் செய்தது. All laws and subordinate legislation in force immediately prior to the commencement of the Constitution shall be published in the Gazette in the Sinhala and the Tamil language as expeditiously as possible. Sinhala and the Tamil languages shall be the languages throughout Sri Lanka, and Sinhala shall be used in as the language of the courts situated in all areas of Sri Lanka except in those areas where Tamil is the language of administration. The records and proceedings shall be in the language of the court. In the event of an appeal from any court, the record shall also be prepared in the language of the court that hears the appeal என்று மேற்பாடு செய்தது. மேற்படி ஏற்பாடுகள் இருப்பதால் இப்போது தமிழ் பகுதிகளில் உள்ள நீதிமன்றங்களில் தமிழ் மொழியே நீதிமன்ற மொழியாக உள்ளது. 1978ஆம் ஆண்டிலிருந்து அதுதான் நிலைமை. ஆகவே தமிழ் மொழி இலங்கையில் நீதி நிர்வாக மொழியாகவும் வழக்குரை மொழியாகவும், அதாவது வழக்காடு மொழியாகவும் சட்ட மொழியாகவும் இருக்கிறது என்று துணிந்து சொல்லலாம். 60களிலேயே இலங்கையில் சட்டக்கலை சொற்றொகுதிகள் தமிழ் மொழியில் படைக்கப்பட்டு விட்டதால் இலங்கையில் சட்டக்கலை பஞ்சம் அதிகம் இல்லை என்று சொல்லலாம், துணிந்து சொல்லலாம். வழக்காடும் போதும் நூலாக்கும் போதும் சட்ட சொற்களின் செம்மைப்பாட்டை உரைத்து உரசி பார்ப்பதற்கு வாய்ப்பு ஏற்படுகிறது. அப்போது ஏலவே படைக்கப்பட்ட சட்ட சொற்கள் செழுமையுற்று மாற்றமும் பெற்றுக்கொண்டே இருக்கின்றன. 1972ஆம் ஆண்டின் அரசியலமைப்பு சட்டத்தையும் 1978ஆம் ஆண்டின் அரசியலமைப்பு சட்டத்தையும் மொழிபெயர்க்கின்ற பேறு பெற்றவன் நான். அவற்றை மொழிபெயர்த்த காலத்தில் ஏற்கனவே இருந்த சட்டக்கலை சொற்கள் சிலவற்றை உரைத்து பார்த்து செம்மைப்படுவதற்கான வாய்ப்பு எனக்கு இருந்தது. நீதிமன்றத்தின் அன்றாட தேவைகளுக்கு அவசியமான சட்டங்களை உடனடியாக மொழிபெயர்க்க வேண்டும் என்று 1978ஆம் ஆண்டில் அரசியல் அமைப்பு சட்டம் கட்டளையிட்டதால் எவிடன்ஸ் ஆர்டினன்ஸ், கிரிமினல் ப்ரொசீஜர் கோட், பீனல் கோட் என்ற 3 கோவைகளையும் 3 ஆண்டு காலத்தில் நானே மொழிபெயர்க்கும் பேரும் எனக்கு கிடைத்தது. அது என் மேசையை என்றும் அலங்கரித்துக் கொண்டிருக்கின்றது. இதை பார்க்க முடியுமோ தெரியவில்லை உங்களுக்கு. தண்டனை சட்ட கோவை, குற்றவியல் சட்ட நடவடிக்கை கோவை.
வெரி குட், வெரி குட்.
அவை நூலிரு பெற்றிருக்கின்றன. அவற்றை மொழிபெயர்க்கும் போது இலங்கையர் படைத்த சட்ட சொற்றொகுதியில் இருக்கும் சொற்கள் பலவற்றை கையாண்டு அவற்றின் திட்பநுட்பத்தை உரசி பார்த்திருக்கிறேன். நான் மொழிபெயர்த்த மேற்படி நூல்களும் 1978ஆம் ஆண்டில் எனது கண்காணிப்பின் கீழ் மொழிபெயர்க்கப்பட்ட நீதித்துறை சட்டமும் எனது மேசையை இலண்டனில் இன்று 32 ஆண்டுகள் கழிந்த பின்னரும் அலங்கரித்துக் கொண்டிருக்கின்றன. தமிழால் முடியும், தமிழில் முடியும். சொல்லும் திறன், சட்டத்தை தமிழில் சொல்லும் திறன் தமிழுக்கு உண்டு என்பதற்கு இந்த 4 படைப்புகளும் சான்று. தமிழிலும் வழக்குரைக்கலாம் என்று அரசியலமைப்பு சட்டத்தில் உரிமை வழங்கப்பட்டிருப்பதாலும் அது ஒரு கட்டளையாக அமைந்திருந்ததாலும் தமிழில் சட்டக்கலை சொற்களை படைக்க வேண்டிய அவசியமும் சட்ட நூல்களை இயற்ற வேண்டிய அவசியமும் இலங்கை தமிழருக்கு ஏற்பட்டது என்று முன்னரும் குறிப்பிட்டேன். தமிழிலும் நீதிமன்றங்களில் வழக்காடலாம் என்ற உரிமையை 1978ஆம் ஆண்டின் அரசியலமைப்பு சட்டம் வழங்கியதால் இன்று நீதிமன்ற மட்டத்திலிருந்து உச்ச நீதிமன்றம் வரையில் தமிழில் வழக்காடக்கூடிய வாய்ப்பும் வசதியும் தமிழுக்கு மேற்பட்டிருக்கின்றன. இலங்கை ஆங்கிலம் லிங்க் லாங்குவேஜ் ஆக இருப்பதாலும் ஆங்கிலத்தில் பயின்ற நீதிபதிகள் உச்ச நீதிமன்றத்தில் இருப்பதாலும் மேல் முறையீட்டு நீதிமன்ற வழக்குகள் பல ஆங்கில மொழியிலும் நடத்தப்படுகின்றன. அந்த நிலைமை இலங்கையில் விரைவில் மாறும். இனிவரும் காலங்களில் உச்ச நீதிமன்றங்களிலும் தமிழிலும் முழங்கும். இந்திக்கு அடிமைப்பட்டு கிடக்கும் தமிழ்நாட்டுக்கு அந்த வாய்ப்பு வரும் நாளை வேண்டி நிற்போம். தமிழகம் உறங்கக்கூடாது. அது உறங்கக்கூடாது என்பதற்காக சம்பத் போன்றவர்கள் சட்டக்கதிர் போன்ற ஏடுகளை தொடக்கி 25 ஆண்டுகளாக பெரும் பணி செய்து வருகிறார்கள். இது ஒரு தனிமனிதனால் முன்னெடுக்கப்பட்ட ஒரு பணி. இந்த பணியை சென்னை அரசு மேற்கொள்ள வேண்டும், சென்னை நீதிமன்றங்கள் மேற்கொள்ள வேண்டும். அப்படினால் சட்ட பஞ்சம் நமக்கு இராது, சட்ட நூல் பஞ்சம் நமக்கு இருக்காது. கலைச்சொல் பற்றியும் ஓரிரு வார்த்தைகள் சொல்ல வேண்டும். இலங்கையிலே கலைச்சொற்கள் ஆக்கிவிட்டோம் என்று சொன்னேன். ஆனால் முழுமையாக ஆக்கிவிட்டோம் என்று சொல்வது முட்டாள்தனமான பேச்சாக அமை. இந்தியாவிலும் தமிழ்நாட்டிலும் கலைச்சொற்களை ஆக்கி இருக்கிறார்கள். ஆனால் அவர்கள் தமிழ்நாட்டில் படைத்த கலைச்சொற்களுக்கும் இலங்கையிலே நாங்கள் படைத்த கலைச்சொற்களுக்கும் இடையிலே வேறுபாடுகள், வித்தியாசங்கள் சில இருக்கலாம். ஆகவே தமிழ்நாட்டில் வாழ்கின்ற தமிழ் பற்றாளர்களும் சட்டவாளர்களும் இலங்கையிலே வாழ்கின்ற தமிழ் பற்றாளர்களும் சட்டத்துறையில் உள்ளவர்களும் ஒருங்கிணைத்து இந்த கலை சொற்றொகுதிகளை ஒரு சீர்மைப்படுத்த வேண்டும் என்பது என்னுடைய விருப்பம். சட்டக்கதிரை நடத்துகின்ற சம்பத் போன்றோர் இந்த பணியை முன்னெடுக்கலாம். அந்த பணிக்கு உதவியாக நான் இருப்பேன் என்றும் கூறி இந்த வாய்ப்பை அளித்த சம்பத் அவர்களுக்கு நன்றியும் மீண்டும் முறை கூறி என்னுடைய சொற்களை இதுவரை கேட்ட ஏனைய சட்ட விற்பனர்களுக்கும் எனது மரியாதையை செலுத்தி அமைகிறேன். வாய்ப்புக்கு நன்றி.
நன்றி. You gave a wonderful speech on legal language of government in Sri Lanka. அதாவது இலங்கையில் உள்ள சட்ட மொழி குறித்த முழு வரலாற்றினை ரொம்ப தெளிவாகவும் விவரமாகவும் எடுத்து கூறினீர்கள். இது பல வகையில் இன்றைக்கு இந்த நிகழ்ச்சியிலே கலந்து கொண்டுள்ள நிகழ்ச்சியினுடைய தலைவர் ஜஸ்டிஸ் கலையரசன் அவர்கள் தமிழ்நாடு ஆட்சி மொழி ஆணையத்தினுடைய தலைவராக இருக்கிறார். அந்த உறுப்பினர்கள் எல்லாம் இந்த இணையத்தில் இணைந்துள்ளார்கள். அனைவரும் உங்களுடைய பேச்சினுடைய கருத்தாழத்தை புரிந்து கொள்வார்கள். 80 வயது நிரம்பிய தங்களுக்கு எங்களுடைய வாழ்த்துக்களை இந்த நேரத்தில் நாங்கள் தெரிவித்துக் கொள்கிறோம். 80 வயது நிரம்பிய பிறகும் 20 வயது இளைஞரை போல, இளம் வழக்கறிஞரை போல நீங்கள் முழங்கிய பேச்சு மிகவும் சிறப்பான பேச்சு. It is a wonderful speech. After 80 years you completed. You got a very lengthy and detailed explanation about the judicial language and legal language of Sri Lanka and how we can compare Chennai, Tamil Nadu and Sri Lanka to implement Tamil as a court language. Thank you, sir. Now,
thank you very much.
Our chief guest this year, Justice His Lordship, Justice Gopal Gowda is here. I'm very happy to welcome Justice Gopal Gowda. He is a very wonderful judge. He served in Supreme Court of India, and he gave a wonderful speech last year in Madurai. I also attended last year. He is always, wherever go, is making a wonderful speech. So I'm very happy to welcome Honorable Justice Gopal Gowda, today's evening chief guest of concluding session. After his chief guest speech, another 2 speakers are there. Dr. Raghunath Reddy, one of the powerful speaker and professor of law university, and another young lawyer, Prem Rajakumari. After chief guest speech, they will present their speech. So all the participants should wait another, probably another 1 hour it will go. Please wait and enjoy the speech. It will be very useful. I'm welcoming Honorable Justice Gopal Gowda to present the speech.
Dr. V.R.S. Sampath, the editor of Sattakadir Tamil Law Journal, and other eminent speakers who have spoken and are going to speak on various topics which are chosen by the organizer. At the outset, on behalf of the legal fraternity and people of this country, I must congratulate Sattakadir Global Conference on Law and Justice organized by Dr. V.R.S. Sampath. For this conference, particularly the concluding session, very important, relevant topics, namely judicial legislation and separation of powers, virtual court and judicial administration, media trial and court trial, judicial administration and legal language, constitutional morality reflections, international trade law and treaty interpretation. These are the topics which are chosen for this concluding session. Eminent senior lawyers who have got tremendous experience at the bar for the decades have addressed already, and other resource persons are going to address on these topics. I carefully listened to Thagarajan, Dr. A. Thagarajan, media trial and court trial. He has presented his viewpoints on the touchstone of the law laid down by Supreme Court very relevantly. This is rampantly going on, the media trial. Media trial is affecting the court trial, violates the fundamental rights of a citizen. Of course, he may be the accused person, he or she may be the accused person. I, with attention, listened to Dr. V.R.S. Sampath, a vociferous speaker who has been advocating to enact the law in the regional language, conduct the court proceedings to enable the public litigant understand the court proceedings effectively and properly and participate in the proceedings, who are seeking justice at the hands of the court of law in India. He has referred to Sri Lankan law, and he has also referred to the various relevant aspects justifying to enact the law by the legislature, even if it is needed to amend the constitution and enact the law to conduct the proceedings in the regional language. There are other eminent speakers who are going to address on various topics we just now referred. According to me, the coronavirus pandemic period, the population of the world has been adversely affected. We have resorted to this kind of webinars to enrich the knowledge. It is very effective. It is in the global level going on, which transmit the knowledge to every one of us. These topics which are chosen for this concluding session will be helpful to the public litigant, law students, lawyers, and the judges. The judges, after hearing both the parties, will render the judgment. That does not mean that we will be knowing everything at the time of administration of justice. My humble view, it is the lawyers who enrich the knowledge of the judges. Therefore, either the constitutional court judges in the High Court and Supreme Court and judges in the district judiciary must participate in this kind of meaningful, thought-provoking the webinars so that knowledge we can enrich and it can be utilized for administration of justice to the people of this country. The preamble of the Constitution of India, which is held to be the basic structure of the Constitution, in 13-judge Constitution bench in Keshavananda Bharati, has held justice, the preamble portion, and constitutional philosophy and the concepts which have been prior to the 42nd Constitutional Amendment. The sovereign, word, socialist, the philosophy and concept, and secularism are held to be the basic structure of the Constitution of India. So administration of justice is a very, very important in this country under the good governance of the Constitution of India. So therefore, the emphasis made by Sampath, Dr. Sampath, a regional language, the proceedings must be held even in the High Court. In the High Court, even in the Supreme Court, the language, it is a country, vast country, multi-languages. Are there? The constitutional framers at that point of time must have thought that English will be the common language that will facilitate the judges, lawyers to render justice to the people of the country. Time has gone on. Now there is a feeling, there are thinkers that in the regional language, the court proceedings must be held to enable the parties understand the court proceedings, effectively participate in the proceedings so that they can get justice. So administration of justice is the basic structure of the Constitution of India. I am very happy that the organizers have chosen the topic of judicial legislation and separation of powers. Three limbs of the Constitution: the legislature, the executive, and the judiciary. The judiciary is required to oversee the functioning of the legislature and the executive. Judiciary is required to interpret the law and render justice and lay down the law. That is the job, very important job conferred upon the Indian judiciary, which is vibrant judiciary. And we also call it as an independent judiciary. Independence of the judiciary is a paramount requirement having regard to the constitutional scheme and the powers conferred upon the legislature and the executive to govern the people who got the mandate from the people of the country, either the parliament or the state legislature. The federal feature of the Constitution is also held to be the basic structure of the Constitution of India. In a situation like this, the judicial legislation is not permitted. The very recent case, the Constitutional Bench, on 6th March 2020, under the new Act, the Fair Compensation Land Rehabilitation Resettlement Act of 2013, which has come into force with effect from 1st January 2014. Very particularly, the earlier three-judge bench Pune municipality's case fell for consideration before another three-judge bench that should not have been referred to another three-judge bench in the constitutional scheme, and the same coordinate bench is not expected, is not legally permissible to hear and examine the law laid down by another coordinate bench. Only that bench could make a request to the Chief Justice to refer to the larger bench than the three-judge bench. So that power is vested with that bench if they are not accepting the law laid down in such case. In the case, the Indore Development Authority case, three-judge bench, they have referred and held, illegally held by three-judge bench, 2:1. It was held that it is per incurium, most the judicial indiscipline on the part of the bench. Then the other three-judge bench, to earlier bench of Pune municipality's case, Justice Kurian Joseph and Justice Lokur, they stayed the judgment, referred to the constitutional bench. The constitutional bench, the same case, Indore Development Authority case, 2020, 6th March 2020. You must have read the provision section 24(2) has been interpreted as and are. That means it is a legislation. The judiciary, while interpreting section 24(2), has usurped the power of the legislative power, which is not the job entrusted to the judiciary. It is every word, every phrase contained in the statute must be interpreted to keeping in view the object and intent of the act. In the case of Indore Development Authority, is a classic constitutional bench judgment that it has exceeded its jurisdiction. The judgment of Indore Development Authority is a nullity. Therefore, judicial legislation is not permissible in India because the separation of powers are there under Article 50 of the Constitution of India. So therefore, the Indore Development Authority case is a classic case where the language, the phrases, words used in a statute of 2013 land acquisition, repealing the earlier Land Acquisition Act of 1894, is a usurpation of the legislative power. There are a number of constitutional judgments in the Supreme Court, right from 1950. It has been laid down consistently by the erudite judges that the power of the legislation is not conferred with the judiciary. So therefore, I'm only telling that judicial legislation is not permitted under the constitutional scheme of the Indian Constitution. And separation of powers, yes, separation of powers, whenever the PIL, public interest litigation, in relation to the policy matters, in relation to the inaction on the part of the executive, there, and also the legislature, law was not enacted. You must have seen Rajasthan case, Vishaka's case, where law was not there, sexual abuse was there. Then the Supreme Court made observation. Any number of cases, the Supreme Court and the High Courts had an occasion to make observation. Law is not there, law is inadequate, law must be adequately provided to render justice to the public litigant. The legislature has stepped in and enacted the law. The classic case is the 1950 Champakam Dorai Raju's case, where the article reservation to the backward class in the religious education institution circular was challenged. Supreme Court has said that it is unconstitutional violation of Article 29. The legislature, the parliament at that point of time, first constitutional amendment to Article 15(4) of the Constitution of India. So therefore, the power of the legislature, executive, judiciary, distinct and clear. Therefore, each limb of the Constitution must understand the constitutional philosophy and the constitutional principle. They must function within the parameters of the constitutional powers conferred upon each one of the limbs of the Constitution of India. Separation of powers, whenever the public interest litigation, state includes the judiciary also, central government, state government, instrumentality, etc., etc. When the central government or state government or a statutory authority or statutory board, statutory corporation failed in discharging their statutory duties coupled with the constitutional function, then the court, public interest litigation, right from 1976, the case which is a very important case is the Ratlam Municipalities case, the public interest litigation, the fertilizer corporation case, and the first judge advocate association case, Gupta's case, and second advocate's case, public interest litigation, and 2010, the Uttaranchal Advocate General case. So when the state fails to discharge its function, the governance is not there under the constitutional philosophy and the scheme. The Supreme Court has stepped in and exercised its power. That cannot be construed that despite the power of executive and legislature, the court has interfered. That kind of argument has been negated by the constitutional benches of the Supreme Court. So this is regard to the judicial legislation and separation of powers. The second important thing, virtual court and judicial administration. For the last 8 months, I have been very vocal in telling this virtual court proceedings is not the proper way of administration of justice. I am a great advocate to tell it has not only affected the rights of the public litigant. In the Constitution, under the constitutional governance, any situation, the constitutional court, district judiciary, who are the guardian of the Constitution, rule of law, render justice to the people, the courts cannot be shut down. It is not permissible. From the viewpoint of public litigant, law and order situation, blatant violation of rule of law, a rule of law in any number of constitutional judgments of the Supreme Court, it has been in unequivocal terms has said, a rule of law maintenance is it is the courts in India mainly responsible to see that rule of law is prevalent. The virtual court, what is that we are going? What is that we are doing? How the lawyers can effectively present the case? I have been hearing from the lawyers. Number of courts were shut down. Trial courts were shut down. Lawyers' practice was completely closed. Lawyers have become pauper. Lawyers have become they don't have the livelihood. See, this kind of the virtual court hearing, yes, it is technology. You can adapt it in a situation like this. But how many courts? Why? 32 judges in Supreme Court, 50, 60, 150 judges in the High Courts. How many judges are functioning? What is the infrastructure provided by central government and the state government for virtual conduct of the cases? Is it effective virtual court hearing? What is the difference between virtual hearing and physical hearing? Why don't you invent? Why don't you adapt a method, infrastructure without affecting the infection, corona infection, either to the litigant or to the lawyer or to the judges, are you not in a position to adapt the alternative methods? So the virtual court hearing, virtually closing down the court, according to me, for the last 8 months, the net product resultant product is 0.5. You may be passing some interim orders in some cases. In Supreme Court, 5 courts are functioning. In High Court, some 6-7 courts are functioning. In the one court, they say, we will hear you if you want the virtual hearing or physical hearing. One lawyer says, I want physical hearing. Another lawyer says, virtual hearing. Virtual hearing, what he makes argument, the hearing lawyer will not be knowing. So this summary of the hearing of the other side, the judge will repeat it. What is the effect of such kind of the proceedings conducted by the court, a constitutional court? Constitutional court is to see that the human rights of the people are protected. How many cases? The cases are thousands and thousands of bail matters are pending. Bail matters are not listed for want of time, for want of judges, the infrastructure. So virtual hearing under the guise in the name of the pandemic. Yes, pandemic is the executive is not functioning. Hospitals are not functioning. The people movement is not there except in the lockdown period. So when the people in the courts are not functioning to the full strength, in the secretariat, in the other offices, people are functioning. One person affecting pandemic, one doctor was telling, if one person is affected pandemic, why are you closing the entire bank? Why are you closing the entire court? So is it the functioning of a constitutional court? Now I am not against the technology using. It may be very useful, but 8 months, the trial is not conducted. The under-trial convicts are in the jail, and in the jail, COVID, there is no proper treatment is being given, monitoring is not given. Psychologically, the people are affected. That is another aspect of the matter. So I am not against this science and technology. I am against not resorting to adopt this kind of, under the guise of the pandemic is virtually, it is not appreciated. It is not acceptable for the people because the lawyers, they are all practitioners. There may be a few lawyers who are well off. The larger number of young members of the bar across the country, they have left their places, gone to their native places. Some of the people have gone and started vending vegetables, doing the hotel business, carrying on with the agriculture occupation. What is this? How can you, when judges are happily enjoying the salary, other perks, what do you must think, you must give direction to the state government, take care of the lawyers. What is that you are doing? If the state government is not in a position to take care of the young members of the bar and the middle-aged members of the bar, what should happen to them and their family members? What about their education of the children? So this kind of virtual hearing has completely judicial administration has been drastically affected. So I am of the view, I am making it myself very, very clear that technology usage, I am not against it. Judicial administration shall not be stalled on any count, much less the pandemic count. And you must the state government and central government must ensure the judiciary, vibrant judiciary must be allowed to function. That has been affected to the larger extent. The another important point is media trial. This is very, 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 very abused by this the fourth estate of the state. What is this electronic media is doing and print media is doing? The classic case, I can tell you, that film actor in Maharashtra state, that what is name? Rahia, what is name? That person after the CBI, that girl was a girlfriend of that film actor, who deceased film actor. Every day morning in the national news, regional news, went on telling, showing the pictures, taking her to the court, taking her to the CBI office, interrogating her, grilling her, and sending her to the judicial custody. And this kind, they're telling one the Republic TV person, he went on telling without knowing, without there being any material evidence on record. So this Tyagarajan was right in telling that they established by law. And criminal procedure code, the procedure code in Indian judiciary under the constitutional scheme, the trial is by the trial courts under the criminal procedure code. That is the procedure established, provided under the criminal procedure code. They are entrusted with that power. Who are these people? To tell, he is the accused person, material evidence is there, he has committed the murder, abetment, cheating, conspiracy. What kind of things these people are doing? You may have a fundamental right guaranteed in Article 19(1)(a). Yes, the Constitutional Court, Supreme Court, right from 1950s, you have protected the rights of the journalist. But under the guise of your journalism, you shall not affect the rights of the public litigant and including the accused person. He has got dignity. He may be innocent man. He may be an accused on account of various reasons he must have been falsely implicated. Then you are telling that this, everything you are telling. Who has given power to conduct the media trial? When the investigation is going on, what should happen to the principle of sub judice? What if the matter is pending before the investigation officer? Does it not affect the investigation officer to conduct the investigation, proper investigation? So therefore, media trial, our government, our parliament and the state legislature have miserably failed, cannot regulate these people, bring them in order. If they, unless these people are brought under control, I think under the guise of freedom of expression, freedom of speech, you are affecting the fundamental rights guaranteed and human rights violation to the people of this country, the litigant. That is, my view is, media trial is totally impermissible, and it is the job of the court trial, and court must conduct fair and reasonable trial in conformity with the constitutional principle and the procedure laid down and the criminal procedure law to court. So the media trial and the court trial. So judicial administration and legal language. This is the subject of Sampath. Judicial administration. What is the administration? The civil jurisprudence, criminal jurisprudence, consumer jurisprudence, constitutionalism, the consumer jurisprudence, various jurisprudence, corporate law, arbitration, conciliation, mediation, the judicial administration in this country is rural population 68%. Illiteracy is more than 50%. Literate people also cannot understand the legal proceedings and legal language, because the proceedings which they conduct, it is only the lawyer and the judge. I don't say to the maximum full extent, either lawyer will understand or the judge will understand. And it is connected with so many material. It is a ocean. The judicial administration is a ocean. Either the constitutional interpretation or statutory interpretation, constitutional interpretation, any jurisprudence for that matter. Judicial administration, unless a minimum, a litigant must know what is going on in the court, what is being recorded in the witness box, whether that recording, what he has said, what is elicited in the cross-examination or examination C. Relevancy, not relevant, and documentary evidence is speaking. What is evidentiary value? Non-admissible evidence, inadmissible evidence, hearsay evidence. What does the legal a common man know about it. So judicial administration is always that the language of the court, at least to some extent, the language of that region is made known to that person, you will in a better position to understand, get judicial administration. I think I am taking much time. I will conclude another 5 minutes. So judicial administration and legal language, when 1986, 5 years course was started in the University College, they requested me to speak, give a lecture. I was associate professor. They requested me to deliver lectures, regional language and legal writings. Legal language and legal writings, the English, the conveyance, and the other, the Criminal Procedure Code or Civil Procedure Code, Transfer of Property Act, Evidence Act, limitation, etc., in the language which is in the court language or the legal language, the people will not understand it. So therefore, we must start telling, make the people to understand what is the regional language, what is a deed of sale deed, what is gift deed, what is will deed, what is 161 statement, what is 164 statement. These are all basic legal literacy must be through the legal literacy, legal services authority. Legal literacy must be inculcated to the people of the country. Then it will be easy for them to know which court, which judge, what lawyer, which lawyer, what they are doing, his case is properly presented or not. Little, at least 10% he will understand. Then he may assist his lawyer. He may tell his lawyer, please put forward, this is the piece of evidence in my favor. This is the document which I have got in support of my case. This is the addendum. This is a record of right. This is my sale deed. This is my mortgage deed. These things he can tell. So therefore, language of administration of justice is paramount consideration according to me, for which, if it is required, of course, under the constitutional scheme, from one court to another court, the judges can be transferred. From one court to another court, the Chief Justice will be appointed. So there will be some problem. But I was the Chief Justice in Orissa High Court. I'll tell you my experience. My experience is I used to ask, I was not giving trouble to the lawyers at all in litigation. They are all poor litigants in Orissa state. Warrior, I used to tell my brother judge, brother, please explain to me the summary of the document in English. That is sufficient for me. Don't take trouble, don't spend money of filing the translated copies of English from Warrior to English. So this we have to adapt method which if a Chief Justice does not understand that regional language, it may be difficult at that time to learn it. If English language is not there, the other person take the assistance, learn it, apply your mind, what is the principle involved, what is the case involved, what is the law to be applied, appreciate it and grant relief. So this is with regard to the judicial administration and legal language. Legal language is very important. Legal language must be told to the people, make them to understand. The court buds, they may not have the law degree. They are the better, they must have acquired over a period, 2 years, 2 decades, 3 decades, 4 decades in the court premises, going to the lawyer's office, coming to the court, sitting in the court hall, listening to the court proceedings. They will well acquaint more than the lawyer, according to me. This is my experience I am telling. Now, so far as the constitutional morality is concerned, I may have to say the constitutional morality is flagrantly violated in this country, right from the district judiciary to the Supreme Court. The classic case is we are interfering, exercising jurisdiction as if that we are all, nobody can question us. The latest trend of the Supreme Court. What constitutional morality? Rama Janmabhumi's case, Sabarimala's case. The Sabarimala case, Article 14 and 15, you may have the custom and practice, and the constitutional bench has written the judgment. Then the review petition, without allowing review petition, you refer to the larger bench, 7-judge bench. What is this constitutional morality? The constitutional morality is the equality, the justice, social justice. What is social justice? Why do you prevent the woman to go to the temple? Why the women are prevented? What is the discrimination? How that custom which is preventing a woman who is a citizen, who is no sense in it at all. We are behaving like uncivilized people. So the constitutional bench laid down the law, interpreted another constitutional bench judgment. I was part of the 3-judge bench, and constitutional bench argument, it has to be referred to constitutional bench. We rejected it. Ramamurthy Justice Senior Counsel argued this point. We rejected it. Thereafterwards, all of a sudden, after summer vacation, the bench was dissolved. This kind of thing, a Sabarimala case, Ram Janmabhoomi case, Ram Janmabhoomi, there is a finding recorded. Finding, what is the finding? The illegality, demolition, insertion of the idols, etc., and preponderance. What kind of preponderance? What is the new jurisprudence? What is the new principles of evidence act are interpreted for the first time by the constitutional bench in a Ram Janmabhoomi case? Now, what kind of this kind of morality we are flagrantly violating? This is my sincere view. I am telling. I can give you hundreds of classic cases where the flagrant violation of constitutional morality. Constitutional morality means what? The fundamental rights are guaranteed, natural rights. The directive principles rights, both are interpreted by Supreme Court in Petana cases, human rights, and fundamental duties. Scientific temperament is the fundamental duty. The integrity of the nation is the fundamental duty. Respecting the national flag is fundamental duty. The respect to the womanhood is fundamental duty. Brotherhood and sisterhood to maintain is the fundamental duty. What is this morality is being followed? Why it is happening? What is happening in Hathara? Why the woman has been raped? The mass rape. It is happening in the country. The constitutional morality. I can speak hours together on this topic. For want of time, I don't want to propose and tell a thing. And international trade law is increasing side, and treaty interpretation. Treaty interpretation, the environmental law has come into force because of we are party to the treaties. The treaty law is the emergence of the National Grand Tribunal Act. So because of it is not contemplated under the constitutional tribunals, but the law is enacted on account of the treaty. We entered into the Stockholm Resolution. The environmental law, the Water Act 1974, Air Pollution Act 1981, Environment Protection Act 1986, these are all on account of treaty, international treaty. And international trade today, because the world over, because of this, the GATT agreement, the world over the agreements, the foreign countries are coming and entering into agreements. The arbitration clause is provided. Arbitration Conciliation Act is the innovative method. The cases which are pending before the courts decades, the industry will collapse, and therefore, on a contractor, National Highway Authority, and the other contractors, thousands of crores of rupees, the execution of work, they are not getting money. If you go to the court, payment of court fee, and struggling for decades, the trial, first appeal, second appeal, 136 is the civil appeal jurisdiction. In that process, even a partition suit in India, there are instances, there are majority of the cases. My brother-in-law's case, my Mawa's case in Andhra Pradesh, more than 45 years. Before I became a lawyer, the trial suit was filed for declaration, injunction. Still, the regular second appeal pending in the High Court. Partition suit, declaratory suit, taking decades together. Therefore, the arbitration conciliation is an effective alternative remedy which is provided by the Constitution. The CPC was amended, Section 89 of the Civil Procedure Code. So, the alternative mechanism for resolution of dispute, either the mediation, conciliation, arbitration, which is provided, which is taking shape in the country, and mediation is a skill, arbitration is also there. A speedy disposal of the dispute between the parties. So these are the things where we have invited your alumni of this internet, the Jindal Global Law School of New Delhi. And these are all very, very important topics which are chosen by the organizer, Mr. Sampath. You must congratulate him. You must encourage him, and conducting webinar of this dimension really appreciated. And I'm sorry, I was not properly communicated. Otherwise, I could have prepared and presented my views. Offhand, I have presented my talk on these topics. I hope that I have done little job for this on these subtopics in this webinar. Thank you very much for giving me this opportunity, Ms. Sampath and other eminent speakers. I love to hear. I know the Madras Bar, Chartered High Court, very erudite judges and erudite lawyers. Erudite lawyers only can become erudite judges. The extraordinary, brilliant, original thinkers, and the plaintiff is very precisely in conformity with Order 6 of CPC, presentation of the case and adducing evidence, arguing the original senior lawyers, all my young members of the bar and judges must learn from the senior members of the bar, erudite bar, excellent bar, knowledgeable, and cream of intellectuals are there at Madras, the Tamil Nadu Bar Association. Thank you very much. Once again, Mr. Sampath, I may be permitted to exit. I have some other engagement now. Thank you.
Thank you, Your Lordship. You given a wonderful speech on various subjects, and it will be very useful for all the participants. They will carry all the information and furthermore to enrich their knowledge and experience. Thanks for your detailed speech, Your Lordship. Thank you. I'm requesting Dr. Raghunath Reddy, Professor, Bharat University, to present a speech on constitutional morality and reflections.
Hello, thank you, sir. Thank you, sir, Dr. Sampath.
Yes, we are listening.
The editor, Sattakadir, and who is also the chief architect of the Global Conference on Law and Justice. And also my dear co-speakers, the chief guest, Justice Gopala Gowda of the Supreme Court, Justice Kalayaresan, and my dear colleagues. It gives me great pleasure to be in your midst for a presentation on constitutional morality. Before I take up this subject for discussion, let me speak something about the Indian Constitution, the nature and the character. The Indian Constitution is the first and foremost a social document. It is an organic instrument, changes the way the society desires. It is a transformative document. So if you look at the Constitution from the commencement till now, with the Constitution framed after freedom struggle, there was a transition of people from the status of British subjects to that of citizens of Indian Republic. Now, the sovereignty is located in the people as per the preamble of the Indian Constitution. And also the transformative character is also reflected in Jammu and Kashmir after the abrogation of Article 370. Now, my dear friends, the benefits of the Constitution are extended to the Union territories of Jammu and Kashmir and Ladakh, conferring fundamental rights. Recently, they have enacted land laws. Now, anyone from even outside Jammu and Kashmir can buy the property in Jammu and Kashmir. So, therefore, now there is a true national integration taking place, and there will be going to be fundamental changes in the lives of Kashmiris. The transformative vision of the Constitution has given value inputs into the system of our governance that it has set up. As a result, there will be constitutionally controlled governance in the country. Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, recognized that in India, the state has never been the sole locus of power, domination, and oppression. Social groups, community structures, religious injunctions affected individuals standing in society as well as their freedom and dignity. Therefore, Constitution, with its emancipatory potential, was meant to interrogate these hierarchical power relations, domination that existed in private sphere, that is caste, groups, family. So therefore, now there is an extension of horizontal rights between private parties after the abolition of untouchability, human trafficking, and forced labor, and prohibition of the denial of access to public places. My dear friends, if you look at the Constitution, Part 3 of the Constitution, there are criminal law provisions available in Part 3. Abolition of untouchability, human trafficking, forced labor. Therefore, constitutional morality is available in Part 3 of the Constitution after the abolition of untouchability, because untouchability, human trafficking, forced labor are constitutional crimes. So therefore, you will find constitutional morality in Part 3 of the Constitution. And as a result, there is a union of trinity, liberty, equality, and fraternity are workable in private domain. Therefore, it will pave the way for extension of internal democracy in the mighty private sphere. So therefore, this is for the translation of transformative vision of the Constitution from medieval hierarchical society into modern egalitarian democracy. So therefore, the Indian Constitution is an important guide, a source of power for impoverished, untouchables, marginalized. Inclusiveness, plurality, diversity reflected in the Constitution are core values deeply ingrained in the Indian society. The inclusiveness in every aspect of life is a manifest, recognizing the role of everyone in society. The doctrine of constitutional morality is thus derived from these constitutional values which form the common basis of the Constitution. It is the fusion. What is the doctrine of constitutional morality? It is nothing but fusion of moral philosophy and the constitutional law. It is having transformative potential. It is an integral part of constitutionalism. It is a restraining principle. It is a constraint on state and non-state actors. Therefore, its function is to circumscribe political power. However, the Constitution is not synonymous with the constitutionalism. Constitutionalism provides ideological context within which the Constitution emerges. It denotes the limited form of government. Constitutionalism has its religious roots in the divine law, philosophical roots in the idea of natural law, its Anglo-Saxon legal roots in the common law tradition, and in
Yes. Hello. Sir? Hello? So, hello? Hello? I think Mr. Raghunath Reddy anyway, is, I think, anyway, we'll call again. Meantime, the Prema Rajakumari will give speech.
Thank you for the brief invite, Sampath sir. Honorable Justice Gopalagowda, Honorable Justice Kaliyarasan, Dr. G. Narayana Raju, Senior Counsel Mr. Wilson, Senior Counsel Dr. Tyagarajan, Attorney Mr. Shrikantaraja, Professor Dr. Raghunath Reddy, legal luminaries, dear advocates and friends, a warm good evening. Being the last speaker of the session, I know it's quite a difficult task and I don't want to stand between you and dinner. So I will keep my presentation quite short. I'm indeed glad to share the screen with two of my professors, Dr. Tyagarajan, as well as Professor Dr. Raghunath Reddy, who taught taxation and international law respectively. So the topic for today's presentation is international trade law and treaty interpretation. With the growing economic interdependence of the world, understanding the system of international trade law is becoming increasingly important. With as much as 50% or more of profits of some businesses coming from transactions across borders, it requires an understanding of the role of law or the lack of law in international trade transactions. International trade law is overwhelmingly treaty-based. For practical purposes, the unique traditional source of WTO law is the WTO Treaty. Honorable Justice Gopalagowda rightly pointed out that laws are being enacted out of treaties. As we all know, most of the countries are members of the WTO, and many countries also have bilateral or regional trade agreements executed between them. Trade agreements in general have dispute resolution mechanisms. Bilateral treaties are concluded between two states or entities. It may have two or more parties. For instance, the bilateral treaties between Switzerland and the European Union following the Swiss rejection of the European Economic Area Agreement. Each of these treaties has 17 parties, but are still bilateral as the parties are divided into two groups, Switzerland on one part and the EU and its member states on the other. Multilateral treaties are concluded among several countries. The agreement establishes rights and obligations between each and every party. Each party owes the same obligations towards all the other parties. The Convention relating to the status of refugees, the United Nations Conventions on the Law of Sea, the Geneva Conventions are all examples of multilateral treaties. As stated out by Dr. M. Gandhi yesterday during the conference, it is not that consent matters, but consensus, which will be the essence of the treaties. Universal treaties are concluded by almost all countries. For example, the United Nations Charter, which is almost 160 parties. These treaties require interpretation, and there are many controversial questions about what might be called the sources for treaty interpretation. What materials can be used to interpret a treaty and how are they to be used? The standard source for answering these questions, especially in the WTO, is the Vienna Convention on the Law of Treaties. More than 40 years after the Vienna Conference on the Law of Treaties codified principles of interpretation in the Vienna Convention on the Law of Treaties, their practical operation still remains contested. Neither the ratification of the Vienna Convention by many states, nor the general recognition that Articles 31 to 33 represent customary international law has resolved the debate over the correct approach to interpreting international treaties. Debates in international law over the correct interpretive approach mirror similar debates in domestic legal systems as well. With respect to the schools of treaty interpretation, there are at least 3 commonly acknowledged schools or approaches to treaty interpretation which correspond to methods of construction of any legal text, including constitutions, statutes, and contracts. In the textualist approach, all solid treaty interpretation begins with the words of a provision itself, as they're commonly understood. Article 31 of the Vienna Convention, in discussing treaty interpretation, calls for an examination of a text's ordinary meaning. Many treaties are drafted in 2 or more languages, and it is vital to ascertain not only which languages are authentic, but also that there may be different shades of meanings of terms in different languages. Textualism can be a form of contextual reading of different provisions in a treaty in order to reach a sensible result. Already, one can see a tension between the text of a treaty provision and the intent of the drafters. However, the second intentionalist approach to treaty interpretation has never been popular. Indeed, the Vienna Convention relegates sources shedding light on the intent of the drafters, including the negotiating history of a provision, to a secondary role. They can be used only when the text is ambiguous or obscure, or the plain meaning of the text leads to a manifestly absurd or unreasonable result. One reason that Trevor may be somewhat disfavored in international law is the concern that some countries might sign a treaty long after it was negotiated and signed. Should these newcomers be bound not only to the text, but also the informal understanding of the drafters? This would unduly privilege the interpretive provisions of the original signatories. Likewise, the use of negotiating history, including earlier drafts of a treaty, reports and commentaries, and diplomatic statements, can be selective and easily manipulated. Despite these cautions, the use of Trevor has become a constant feature of interpretive disputes over treaties. Teleological approach, also known as purposivism, seeks to effectuate the purpose of a treaty rather than slavishly following the text or attempting to divine the intent of the drafters. It is captured in the Vienna Convention's requirement that treaties be construed in light of their object and purpose and in view of relevant rules of international law. The goal of this approach is to interpret a treaty in a way that gives scope to the fundamental reason or problem it was supposed to address. This approach is especially common with more organic or constitutional treaties, including those that establish international institutions such as the United Nations Charter of 1945. There are limits to the teleology in treaty construction, and interpreters cannot take the purpose of a treaty too far. For example, the International Court of Justice has flatly rejected the notion of maximum effectiveness, construing a treaty so as to give it the fullest effect. In an advisory opinion during the 1950s, the court ruled that peace treaties concluded by Eastern European states containing arbitration clauses could not be construed so as to give the United Secretary General the power to appoint arbitrators if the states themselves had refused to do so. The Vienna Convention serves as a common frame of reference within which diverse national courts interpret treaties. National courts often do not expressly refer to the Vienna Convention when interpreting treaties. Yet, the more interesting question is whether national courts apply the Vienna Convention's interpretive provisions in substance, whether they recognize that the instrument in front of them is a treaty that deserves to be treated differently due to its character rather than domestic instruments such as contracts or statutes. As a matter of practice, national courts routinely accept that the Vienna Convention's principles represent a useful toolbox for interpreting treaties without these principles being formally binding. On the flip side, this stance also enables national courts to use other domestic interpretive tools when they choose. Given the Vienna Convention's inbuilt flexibility, there is no guarantee that the application of the Vienna Convention's interpretive provisions leads to a different result by the same treaty interpreter. As part of a general international law, the Vienna Convention principles on interpretation are the interpretive methodology of choice for international courts and tribunals. At the same time, national courts are typically more familiar with domestic, sometimes unwritten standards of interpretation. Their natural habitat is the interpretive framework provided by their own legal system. They're often inclined to use those standards in treaty interpretation singly or combined with the Vienna Convention law of treaties. Even when the national courts apply the Vienna Convention law of treaties interpretive principles, the application may be colored by national legal culture, including evolving national approaches to statutory and contractual interpretation. Here I conclude with special thanks to Dr. V.R.S. Sampath for his service in publishing the premier Tamil law journal Sattakadir for the last 28 years and voicing out the opinion of the majority through the editorial column of Sattakadir in every contemporary legal or social issue. Thanks again, sir, for convening this conference on law and justice, and thanks to all the viewers for your patient hearing. Thank you.
Thank you, Rajakumari. You given a wonderful and a special subject on international law. It will be useful for the many students participating in this conference. So I'm very much thankful to you. You've taken a lot of pain to organize this conference, to design the invitation. You've taken a lot of initiative to fix the various VIPs and played a major role to conduct this conference. And thank you for your, I'm mentioning especially, thank you.
Thank you, sir. My pleasure.
And I'm requesting that the line was disconnected because of somebody interfered in the mute. That is why the line was disconnected. I'm requesting the Professor Raghunath Reddy to continue his speech.
Should I continue, sir?
Yes.
Yeah, thank you. So the constitutionalism is not a creation of the judiciary nor innovation. The antithesis to constitutionalism is despotism. The adoption of the Indian Constitution was in a way as an instrument of agency for achieving constitutional morality. For that matter, the idea of constitutional morality was first introduced by Dr. B.R. Ambedkar. For him, it refers to respect, reverence, and internalization of the form as well as the spirit of the Constitution. He believes that the constitutional morality is to be diffused among all, not only among the majority, among all the community and throughout the whole. The constitutional morality has been existing in England as well as in America. The preambular message forms part of the norms of constitutional morality. Granville Austin expounded the constitutional morality in terms of the goals of social revolution. Consequently, the revolution would bring about fundamental changes in the structure of the Indian in the structure of the country. The core commitments to social revolution lie in Part 3 and Part 4, which is the conscience of the Constitution. Therefore, it is submitted that the doctrine is nothing new and deeply rooted in the Indian Constitution, which is the fundamental law. It is neither emergent nor resurgent. The doctrine is fully convergent and it is inbuilt in the Constitution. It is the Constitution centric. It is to civilize the practices and humanize the society. It is part of the basic structure which is in consonance with the spirit of constitutionalism. It is an inherent ab initio in the Constitution itself. The law, there is no difference between law and morality in the beginning. The law the law without morality is a tree without roots, and morality without law is a tree without fruits. So therefore, the very existence of society, the survival and growth depends upon our value system. Values are the social ideals. They change with the progress of society. Values are the lifeblood of law. Therefore, they are the moral ideals upheld by the public. It is the morality which conditions the conduct of the community. If morality changes, law also changes. Law follows the change. Thus, morals perfect the law. The Lord Devlin mentioned that law should continue to support at least minimum morality. Devlin observed public morality provides a firm structure to any human society, and that the law, especially criminal law, must regard its primary function to maintain this public morality. The views of Lord Devlin received support from House of Lords in Ladies Directory case, where Lord Simmons held that conspiracy to corrupt public morals was common law misdemeanor in England. This case emphasizes the role of values as ultimate source of law. Lord Mansfield maintained that law of England prohibits everything which is contra pro bono bonus. Any attempt to undermine public morals is a dictum of Lord Mansfield, was reiterated by Simmons. Lord Mansfield pronounces the state of slavery to be incompatible with public morality. In the pioneering case decision of Somerset, the case assertion of ownership by slave owner over the slave was rejected. The tenets of social morality are devised in order to curb intra-group aggressiveness, reduce predatory and unconscionable practices, cultivate concern for one's fellow men, and thereby increases the possibility of harmonious coexistence. The social morality may be viewed as the recognition of objective hierarchy of values which are to guide the human conduct, the conduct of human beings towards one another in a given society. There are universal values. They are the core legal principles. Cardozo recognized these principles as extracted from pre-existing law, and constantly they are being tested, retested, and reformulated. Cardozo attributed a direct force to these principles. Fuller proclaimed a right in it as a demand founded on these principles. Therefore, principles are concerned with the promotion of rights. They are the means by which an individual is treated with the same respect and concern as everyone else. According to Dworkin, the basic principle is the key to the integrity of law. These basic principles are found abundantly in the Indian Constitution. These principles are subsequently blossomed as several doctrines, and these doctrines are inherited from the common law principles. One such doctrine is constitutional morality. The doctrine of basic structure inherited from common law is conceived in terms of certain basic principles, values, underlying the basic document, that is the Indian Constitution. These principles are the values, pre-constitutional values, universally accepted in terms of certain basic human rights that are considered essential for the very existence of human being. Common law doctrines have developed fundamental human rights. They are assumed, assimilated, intrinsic, foundational values which exist as such in the scheme of the nature. Such values exist independently of any constitution. In the common law tradition, these values are founded in the common law constitutionalism. They are invariably crystallized in the constitution in the form of fundamental rights which occupy a unique place in the lives of civilized society. Therefore, principles of basic structure of the constitution comprises the fundamental principles. The doctrine of constitutional morality is a part of basic structure doctrine. This basic structure doctrine made the Indian Constitution an enduring document. The Supreme Court termed the doctrine of constitutional morality as the second basic structure doctrine. It is reincarnated as basic structure doctrine under the Constitution. Even after the Constitution came into force, there was though there was a transition from colonialism to republicanism, the colonial tradition of social exclusion and discrimination through penal provisions persist in India. Still, there are rampant social inequalities coupled with prevailing prejudices against sexual minorities in the post-constitutional era. The achievement of goal of constitutional minority freedom has been a non-starter in the background of heteronormative hegemony in the country. The question arises, is it not amounting to exclusion of colonial tradition of social exclusion policies through penal laws by criminalizing homosexuality, passive begging in the post-independent period? Colonial hangover in Indian laws in the form of criminalizing adultery on the one hand, passive euthanasia remained on the statute book even after 70 years of the Indian Constitution. Therefore, there are certain acts previously deemed to demonstrate a degree of immorality requiring legal prescription were taken out of the domain of law and relegated to the sphere of individual moral judgment. In England, homosexual acts between consenting adult males were removed from the reach of criminal law. The crime of attempted suicide was abolished in England. A decriminalization of extramarital intercourse, therefore, that is adultery, has been accomplished. When adultery is no more a crime in a country from where it was originated, how can you accept this presence in the Indian Penal Code? A.K. Gopalan and the emergency case bulldozed constitutionalism. The post-emergency Supreme Court, after coming out from the curse of legalism and formalism, became activist court sensitive to the sufferings of poor and marginalized. Post-Maneka, Article 21 became a reservoir of fundamental rights. There was a shift in the approach of Indian judiciary from conservatism to pragmatism while employing the doctrine of constitutional morality. In the process, the meaning and content of the doctrine has been completely transformed to serve the larger social purpose and reconstituted to suit the present context and render ameliorative justice. It is in this background the doctrine of constitutional morality assumes significance in checking the unprincipled criminalization policies. Section 377 IPC criminalizes homosexuality. Delhi High Court in Naz Foundation decriminalizes homosexuality. However, the Supreme Court in Suresh Kumar Kaushal recriminalized homosexuality. At last, the Supreme Court in Navatej Johar decriminalized homosexuality. Section 377 IPC criminalizing homosexuality is modeled on English criminal law. The traditional religious and moral ideology perceived homosexuality as a sin and perversion. A stigma was attached to this practice. Section 377 IPC branded homosexuals as criminals and deviants. The framers of the code, obviously relying upon the then prevailing sexual mores and common law of buggery, decided to criminalize carnal intercourse against the order of nature. The Wolfenden Committee strongly argued that consensual homosexual act between consenting adults in private does not harm others. In what way homosexuality is harming others? In what way passive begging is harming others? The committee also relied upon Millian doctrine that legal intervention in private life is only justified in order to prevent harm to others. The Delhi High Court in Naz gave new language to morality and was eloquent in saying that homosexuality should remain in a realm of private morality in a law-free zone. Therefore, criminalization of homosexuality on the ground only of sexual orientation is offending Article 14, 15, and 21 of the Constitution. Constitutional morality requires LGBT persons are to be treated as equal citizens of this country. Diversity of different sexual orientation of LGBT community and their gender identity is recognized in NAS Foundation. NAS Foundation drew heavily on the privacy jurisprudence of the American Supreme Court in Lawrence in declaring Section 377 IPC as unconstitutional. NAS has recognized the court as counter-majoritarian institution. The majority opinion and popular acceptance reflected in popular morality do not furnish a valid basis for denial of legal rights of LGBT and queer community founded on sound constitutional doctrine. Only when the dignity of the LGBT persons is respected, the Indian Constitution lives up to its foundational promise. Therefore, NAS recognition of right to choose intimate partner of homosexualities provided some space for the little communities of love. Gay marriages are legalized world over. Gay rights are recognized as human rights. It is to be noted that discrimination against a minuscule minority population is antithetical to constitutional ethos and disrespectful to the historical memory of the oppression suffered by these people. NALSA, National Legal Services Authority's case, is a landmark one which upheld right to choose one's own sexual orientation. Transgender, even though insignificant in number, they are entitled for human rights, as observed by the court in NALSA. In NALSA, the court, while articulating a charter of rights for transgenders, noted that Section 377 IPC effectively targeted specific identities. NALSA recognized transgender as a third gender by treating the issue as a human right issue. The Supreme Court in NALSA had held that transgender persons have the same right to identity as a gender of male, female, or transgender, irrespective of medical sex reassignment and right to expression of their chosen gender identity. Time has come to decriminalize passive euthanasia. Supreme Court in Common Cause versus Union of India legalized assisted suicide. Consequently, the autonomy to die is recognized in Common Cause. It also endorses the freedom of the competent individuals to make choices about medical care and also the principle of technological self-determination. It is a welcoming step of the apex court, which has addressed the long-awaited demand for legalizing passive euthanasia in the Indian legal system. The court verdict has paved the way for peaceful ending of life of the terminally ill patients. One can witness the influence of Puttasswamy, K.S. Puttasswamy, famously called privacy judgment, on the Supreme Court in restoring Hadiya marriage. The court opined that Hadiya is having internal freedom of choice, marriage, and autonomy. The Supreme Court has clarified right to convert is a fundamental right of choice. The court observed that freedom of faith is essential to his or her autonomy. Choosing a faith is substratum of individuality. The court came down heavily on the crimes committed in the name of honor by upholding the choice of consenting adults to love and marry as part of their fundamental rights. The apex court said that honor killing gilotines individual liberty and freedom of choice and one's own perception of choice. It is submitted that court has once again applied a Puttasswamy judgment in Hadiya case. The court maintained that the state and even the parents could not interfere with the freedom and encroach into their marriages. One can witness the anxiety of the Supreme Court in upkeeping the constitutional morality in these cases. Nalsa and Puttaswamy together laid foundation for decriminalizing consensual gay sex. The Supreme Court in Navtej, while striking down Section 377 IPC, recognized constitutional extraordinary transformative power. The Supreme Court held Section 377 does not survive the Trinity test of Article 14, 19, and 21. The doctrine of constitutional morality is thus playing socially inclusionary role of law. Discrimination on the basis is deeply offensive to dignity, identity, privacy, and self-worth of the individual. The idea of different sexual orientation as a value strengthens the diversity of Indian society and thereby fosters constitutional morality. The court viewed that a minuscule fraction of country's population constitutes lesbians, gays, bisexuals, transgenders, what's not sustainable basis to deny right to privacy. If you look at the inclusiveness of the Indian polity, the Indian society, the classic example is the former President of India, Dr. K.R. Narayanan, who was the former President of India, who is elevated, who was elected as the President of this country from a scheduled caste community. So that shows the inclusiveness of this great country. The Supreme Court in Indian Young Lawyers Association held that Hindu religious practice of not allowing women of the age group of 10 to 50 years to enter into Sabarimala is unconstitutional. The court, by employing the doctrine of constitutional morality, found fault with exclusionary practice as not in accordance with the status of essential practice of Hindu religion. The morality appeared in Article 25 and 26 of the Indian Constitution was meant for constitutional morality. According to the court, women are not lesser citizens of God. They are, on the other hand, equal citizens of this country. Therefore, denial of women entry into temples, mosque is against the equality cause under the Indian Constitution. The multifaceted, multidimensional concept of privacy protects heterogeneity and recognizes plurality and diversity of culture. It is one of the core freedoms. Having increasingly recognized sexual privacy jurisprudence around the world, European countries and many states in the US have repealed adultery laws. In India too, the constitutional validity of the offense of adultery was challenged in Joseph Shine versus Union of India. Following the global trend and Puttaswamy dictum, the Supreme Court in Joseph Shine decriminalized adultery, which is an ancient vintage on the ground of sexual privacy. Section 497 IPC is a colonial relic based on Victorian morality. Further, it is based upon male chauvinism, which assumes that wife is the property of her husband. Whether the wife is the property of her husband, consequently, it is violative of Article 14, 15, and 21 of the Indian Constitution. Therefore, the dominant moral, social, normative structures, public morality, religious dogmas embedded in criminalization of adultery could not withstand the test of constitutional morality. Bombay Prevention of Begging Act 1959 made soliciting alms in public places an offense. Delhi High Court decriminalized begging and declared unconstitutional several provisions of anti-beggary law. The criminal conduct of need-based passive begging is clearly in violation of constitutional morality. Now it is decriminalized. Homosexuality, adultery, passive euthanasia, passive begging, etc. do not any harm to the society. Therefore, my dear friends, it is submitted that on the one hand, Devilian notion of legal positivism and Manfield's dictum of attempt to corrupt the public morals on the other hand made them offenses on ill-founded public morality and social morality. If you look at the personal laws, personal law matters were one of approach at once. Now, gradually, the judiciary ventured to scrutinize gender discriminatory practices, gender bias, and inequality on the touchstone of Indian Constitution so as to secularize family law and democratize the rights of women. Recently, the Supreme as unconstitutional on the ground of violation of fundamental rights by declaring that fundamental rights stand on the higher footing than personal laws. It is in accordance with the trend of modern democratic thought. It is to establish the government of law, not of man. A governing system, a governmental system where the tyranny of majority does not oppress the minority. So therefore, my dear friends, constitutional morality is deeply adumbrated in the transformative Indian Constitution and constitutionalism. The doctrine of public morality was subject to the scrutiny of constitutional principles by the Indian judiciary. Social, cultural, and religious other exclusionary practices Victorian morality were made amenable of rights. Akin to just cogence norm, constitutional morality became the fundamental norm of the Indian Constitution. Xenophobia, homophobia are anathema, antithetical to constitutional morality. While constitutional morality justifies the constitutional crimes of untouchability, human trafficking, and forced labor, it decries criminalization of passive begging, homosexuality, attempt to commit suicide, and adultery. The Supreme Court, after the Supreme Court decisions in homosexuality and decriminalization of homosexuality and decriminalization of adultery, there was a Twitter for me. Now, a person can go with the wife of another person to Sabarimala. The Supreme Court has pitted the constitutional morality against public morality. Consequently, it was a counterpoise to popular morality. In the process, judiciary has entirely transformed the meaning and content of the doctrine of constitutional morality for the realization of constitutional goals. The doctrine is useful in guiding the public policy decisions. Constitutional morality is neither innovation nor renovation by the judiciary. It is the vision, aspiration of Dr. B.R. Ambedkar. Dr. B.R. Ambedkar has rightly expressed that constitutional morality has to be cultivated by inculcating the habit of obedience of the Constitution. It basically means how bow down to the norms of Indian Constitution. While the doctrine of basic structure is antidote to unlimited power of Parliament, the doctrine of constitutional morality is antidote to the tyranny of majoritarianism. Therefore, the job of a judge ultimately requires balancing different interests. It requires balancing between the principle of majority rule and values which even the majority may not undermine. Thank you very much for giving me an opportunity. I thank Dr. Sampath, the editor of Sattakadir, who is the organizer of this seminar, this webinar. Thank you. Thank you very much.
Thank you, Professor. You've given like a river water, like that your speech is non-stop, and also to every bit of the speech is very useful and wonderful. You have a law, very rich experience teaching constitutional law and other thing. The people is a student lucky to listen your lecture. Today we had an opportunity to listen your lecture. So wonderful. We can call you again for some other occasion. Thanks for Professor. Thanks for our good friend Dr. Jagat Rakshakan, taken you as a professor of law in this law school. You've given a very, very interesting topic. Thank you, sir. Thank you.
So kind of, sir. So kind of.
Thank you. Now I am requesting Dr. Meenakshi Sundaram, advocate, and also part-time lecturer, and also our board member will say a word of thanks.
Good evening to everybody. A great pleasure and thank Dr. V.R. Sampath, editor, publisher of Sattakadir, who is conducting this 28th global seminar for 3 sessions consisting of 2 days, inaugurated by none other than the Supreme Court Judge Honorable Miss Banerjee, and followed by Ms. Raja, who delivered the presidential address. And the third session, who is done today, is inaugurated and presided by Mr. Kalerajan, Honorable Judge, Madras High Court, and presently the chairman of the Language Commission, followed up by Mr. Justice B. Gopal Kauda, former judge of the Supreme Court of India, and followed by Mr. J. Viswanathan, one of the mentor of Sattakadir, followed by various legal luminaries who delivered on various topics. And for want of time, and it went on for 3 hours, I thank one and all who graced this occasion in large number. And it is an unusual attendance which only Mr. V.R. Sampath is able to gather, even in virtual hearing, more than 220 people, and that too stayed for the entire time. I thank every one and all for making this occasion a great success. Thank you, sir.
Thank you, Professor Dr. Meenakshi Rao. The only one thing I missed there, our chairman, Dr. Kalerajan, conclude any notes. Any
Thank you.
Yes, sir, Dr. Kalerajan. Because he's the chair.
Only thing, in this global conference on law and justice, laws from domestic level to international law have been dealt with. I congratulate Dr. V.R. Sampath for wonderful and relevant topics of the day for presentation. That is, நான் சட்ட ஆட்சிமொழி ஆணையத்தின் தலைவர் என்ற முறையில் நமது அட்டார்னி எஸ் ஸ்ரீகண்டராஜா அவர்களுக்கு சொல்லிக் கொள்வதெல்லாம் அவர் சொன்னார், ஒரு யூனிஃபார்ம் லா லெக்சிக்கன் அவர்களும் நாமும் தமிழ்நாட்டினரும் சேர்ந்து செய்ய வேண்டும் என்று. நான் இந்த ஆணையத்தின் தலைவர் என்ற முறையில் உங்களையும் தொடர்பு கொண்டு டாக்டர் V.R. சம்பத்தையும் தொடர்பு கொண்டு இதற்கு அனைத்து நடவடிக்கைகளையும் எடுக்கிறேன் என்பதை மட்டும் இந்த தருணத்திலே சொல்லிக்கொள்ள ஆசைப்படுகின்றேன். தேங்க்யூ.
நன்றி, Honorable Justice. Very wonderful decision about inviting Sri Kandaraja to discuss about creating a law lexicon for in our Tamil language. It is a wonderful information, and I'm requesting every speaker to send their text speech for us to print a booklet on this whole conference. Even if you are missing any part of the speech, you can include in the text speech and send it to our email ID. Our coordinator, this conference coordinator, Ms. Prem Rajakumari, will contact everyone and take necessary steps to collect all the articles to print the judgment, print the booklet very soon. Thank you, one and all. I'm very happy everyone participated and listened all proceedings. Yesterday, 3-hour session. Today morning also 3-hour session. Now more than 3-hour 15 minutes, 30 minutes session. So we all enjoyed it. Thank you, thank you, thank you. We are closing now. Thank you. Thank you, thank you.